on the record. Case number Delta 1314 dash Charlie Bravo dash 2019-01401 in the district court, in the 13th Judicial District Court in Valencia County, New Mexico. The time now is 34 minutes past 10 in the morning. It's Saturday, February 13 of the year Lord 2021. This court is now open under Title 28, U.S. Code Section 636, Golf, lowercase, in this Superior Court of Record, where for the Honorable J. Jesús-Arriaga Alonce, Federal Postal Judge sui juris is presiding in this Superior Court of Record and in the Corporate United States District Court for the Corporate District of New Mexico, to the attention of the Honorable Chief Justice John G. Roberts in the Supreme Court of Justice for the District and the Supreme Court of Justice for the United States. Today we're going to start a case. The case number we just mentioned is being brought against for the Honorable Adelina Column. Adelina hyphen Arriaga Column Pedrosa. It is against the fictitious name Adelina Arriaga. This case is about a foreclosure where for the Honorable Adelina Arriaga Pedrosa is not a defendant. And for the Honorable J. Jesús-Arriaga Alonce is not a defendant. Disclosure do not exist. Disclosure is a fraud. These people are creating obligation in violation of Title 18, Section 514. I believe I will have to check on that. It's Title 18, Section 514, I believe. Yeah, I think. If not, I will have to correct it. I have too many numbers here in my head. In this video, we're going to have a series of events that we announced on January 6th of the year Lord 2021, where we announced that we were going to start presiding in this case in relation to fraud. This is about federal mortgage fraud. To give you a roadmap of what is going to happen, and we're going to be reading these documents, but first we invited one of our team investigators to make an investigation in regard, and this is real. This is a case that it is going to be presented as case law. Okay. We are going to have the honor to bring into the record a video that is presented by the Honorable Robert Allen Radlusky. In this video, you're going to witness firsthand the transaction as is made and the faults and the mistakes, the de factos on this transaction. And then when the video ends, we're going to introduce another video in which we're gonna have you, Chief Justice. We're gonna have you swearing Donald J. Trump because we sent him documents and he failed to perform on a ministerial duty and the witnessing of a constitutional wrong. This case was referred to the Oval Office at the White House. And now, when we get there, we're gonna read the document that we sent to the Oval Office at the White House. For now, I am going to play this video, which is the introduction of this forensic evidence into the record by the Honorable Robert Allen Rayluski, the Staff Sergeant for the United States Army or Armed Forces. And then you're gonna take your notes, see exactly what he's talking about, because he's gonna be able to show it to you from the book. This is what we do. I am a constitutional. For the Honorable J. Jesús-Arriaga Abonce is a constitutional federal postal judge sui juris, uomo sapiente, culto, erudito, a special master in common law, an auditor, and black law, corporate law. Sui juris. And for the Honorable Column, Adelina, hyphen, Arriaga, Column, Pedrosa. And for the Honorable Column, J, period, Column, Jesús, hyphen, Column, Arriaga, Abonce. I'm going to place this in front of you now, and I will come back when this video is finished. We will continue. We're going to cover a lot of ground today.
Hey everyone, it's Rob Ryder. It's July 13th, 2012, late at night. We're going to look at a case that just happened in, or just came out of the appeals court in Ohio, and talk about what happened here. But this is the original complaint, 2010-12-7967. And it's just a complaint for money and foreclosure. But it's got some ramifications to it. Let's take a quick look at something here. So first of all, this is the original complaint, and then this is the appeals case that just happened June 27th, 2012. And I'm going to show you how to find those, so not too hard to find. If you go to Summit County, Ohio, at this particular link, or cut and paste it, whatever you need to do, you can look at all their court records. You can look at every document that was submitted into a court case, or so it appears, and at least for these you can. So the appeals court, the name is Haydu, there's the case number, and of all the interesting things that could be said, this is the one that is really going to be the downfall of all mortgages, because it said in paragraph 14, moreover, in its complaint, Third Federal set forth a claim for foreclosure pursuant to the terms of the mortgage, which it attached to the complaint. In regard to the mortgage, Third Federal did allege in its complaint that it had complied with all conditions precedent under the terms of the mortgage. However, when reviewing the mortgage attached to the complaint, it incorporates by reference the terms of master mortgage, and references the master mortgage's recorded instrument number, but no copy of the master mortgage is attached. For review of the mortgage attached, we cannot discern the conditions precedent to commencement of the foreclosure action. Thus, based upon the allegations of compliance with conditions precedent, we can only presume that these conditions are set forth in the master mortgage, which was not attached to the complaint, in contravention of some Civil Rule 10D. Under these circumstances, we conclude that the material question of fact existed as to the terms set forth in the master mortgage, and as the affidavit in support of the motion for summary judgment did not supply the missing terms of the mortgage or incorporate a copy of the master mortgage, Third Federal failed to meet its initial Drescher burden of establishing the absence of question of material fact of issue, or on the issue. A lot of talk about a thing called a master mortgage is what it's coming down to. And the master form mortgage they're talking about is the first lien. Your deed of trust mortgage that you have in your property file is actually a first lien security instrument. It's not the lien, it's a security for the lien. The first lien is this thing called a master form mortgage. And if you go to this Fannie Mae site that I have on there, you'll find some evidence of this, where for security instruments, first lien security instruments. And then there's these things down here called the master short forms for particular states. Now, not all states use this system, but hey, we'll take what we can get and we'll figure the rest of them out. But Ohio does, and that's where this case came out of. They use a master form mortgage. So in the complaint, they're talking about this master form mortgage. So let's go look and see what they put on the complaint. And again, you guys can read all this stuff at your leisure. But on the complaint, if we go down to page 8 of the complaint, it says at the top, master mortgage form. Now, this is the only piece of paper that has that at the top of it in this complaint. And as you can see, it says the master mortgage form recorded on 4/19/04 pursuant to some codes in the county, instrument number, but it doesn't have a book page or by. And since those are blank, it's never been recorded. So it's never been lawfully recorded. And that's what they're talking about here. And so at the top of this page for Fannie Mae, right, again, these are all first lien security instruments. Every state has one. So the thing you have in your property file is a first lien security instrument. What you want them to show you is the first lien. And in the master form states that use that process of the master form, of which there are these, they're really specific on what they have to do. And in the state of Ohio, where this is from, it would have to have this title page on it. And this is what it will look like. Looks like this. And it says everything in the box is the important stuff. The master mortgage form recorded by, and there has to be the name of a person in there. Can't put a bank in there. It says name of person. On behalf of, and then the name of the lending institution needs to be in there. And then this master mortgage form is being recorded pursuant to Ohio Revised Code 5302-15, 2006. When you go look that up, it'll also reference 16 in it. And in those two statutes, it says this form must be recorded before any deeds of trust, first lien security instruments, these up here, can be issued. And so for Ohio, the mortgage is going to look something like this. And it's just a standard mortgage form, and they can't, but the important thing is they can't issue that until this has been recorded. And they say themselves that it has never been recorded. There's no book or page. We found down in Florida also that most of these aren't recorded. Recorded means to be recorded, and in every case, on every state that uses this system, it will have the codes that say how it has to be recorded. So you have the evidence of their own laws that say what has to happen before they can issue any first lien security instruments, or they can issue any of these, and for them to be valid, this has to have been recorded in these particular states. Ohio's one of them. Okay, so if it isn't, then there is no first lien. Therefore, you're paying on a false obligation, which is Title 18 U.S.C. 514, the Criminal Code, Federal Criminal Code. And just for good measure, it's contempt of court to sue in the name of a fictitious plaintiff, Black's Law Fifth, and others. So if you're in a foreclosure, you can do anything else you want. I really can't tell you how to do this stuff, right? But I'd file a motion for an emergency hearing to point out this contempt and criminal activity under the seal of the notary. All right, so you're going to, whatever your motion is, you go do it, and you put down there that, basically you swear and affirm the best of your knowledge that this is true. You're not saying it is true. You believe it to be true. So and then you have a notary seal it, and that way it's a court record. I would even get the certificate of authority for the notary. That's just the way I am, right? The idea is you can make it a public record. And Lord Coke said back in the 16th century that if you have the ability to bring in the best evidence and you don't, the case should be heard against you. That's the way their system works. And you have the ability to bring in the best evidence because you can make a public record, full faith and credit of the Constitution. So, you need to put seals on your paperwork. It's very important. They don't. Here, look at this complaint. Let's go back to page 4, right? Page 3. It's a 3-page complaint, right? They get done talking. Here's the attorney's signature, but there is no seal. He didn't say anything under oath. He's not making... There's nothing here even says that he believes this to be true. He's not gone under oath. Well, you can't do that, right? In law, plaintiff must appear in proper person, provide evidence under penalty of perjury to substantiate his claim. So the plaintiff whoever the plaintiff is, has to have done this complaint under oath. It's not on there. So somebody tried this down in Ohio that Gene Keating's been working with, and Gene helped him write up an emergency hearing motion, and now they have one. And they've pointed out these defects in the law, and you're going to see that their attorneys are going to go to jail. They have brought fraud into the court because they're claiming that you owe this. Right? They're claiming that you owe that money on a false obligation for the very simple matter. This is so simple. It's just, you're going to have to wrap your head around this. They're going to provide the frickin' evidence. The master mortgage has not been recorded. If it's not been recorded, you can't write any frickin' deeds of trust off it. Therefore, all those securities come back to you. Everything that you've paid, plus 3 times damages. So, you know, those of you that are much smarter about putting paperwork into court than I am, please look at this, because this is what they don't have. They don't have the master form mortgage or master mortgage form or whatever the hell they want to call it, not recorded. They're providing the evidence themselves. Once this is entered into the court record, you know, it's public record. And public record says it's not been recorded. They're giving you the evidence. Use it on them. So this is a real short one. That's all I really wanted to get out, because I know that a lot of people might be able to use this if they would just go put in the right motion. And I'm not the guy to ask about doing motions. I don't do any court paperwork. But if you're in a case, you know, ask them how you put one in. My point is, do it under the seal of a notary when you're done. That way they have to see it when you put it in the court record. And have them put the file stamp on the back. That's one last thing here. I think it's really important. When I was talking to Tom here a bit ago, he was saying when one of his buddies was in with this paperwork we've been doing, as the judge was getting ready for the court case and talking, he was looking at the documents and flipping it over and looking at the back. At the back, at the back. Even the guy's certificate of live birth that he had recorded, and he was looking at the back. They're looking for a seal. And by definition, for the word file, when it comes to the clerk of a court, they're supposed to endorse the document with their file stamp. And again, endorse means the back. So if they put the file stamp on the side with the writing, they're saying that's the back of the paper. And what does the judge see? He doesn't see anything, because, you know, that's the game they play. I just think, you know, people talk about putting stamps on the back and signing them across and thumbprints, all that kind of stuff. Yeah, I can see where you'd do that. But, you know, if you put a notary seal on there and say that you left this page blank intentionally, maybe that makes them keep an eye on the front. Or tell the clerk, I want you to put your file stamp on the back side and question her. Go look the definition up yourself and take it in and say, look, it says here you're supposed to endorse the document with your file stamp. That would mean it's the back of the paper. And have them go get a ruling at law. So, okay, that's really all I had. It's really that simple. Make the right argument. Point out the defect in due process of law. And quit arguing the facts. We'll see.
Any questions? If you said no, you knew. If you said yes, you did not know. But you knew, or you should have known. That is the real problem for you. For the trespassers. For the terrorist. For the terrorist attack we are suffering under these thieves. Now, for the Honorable J. Jesús-Arriaga Abonce, and for the Honorable Adelina Arriaga Pedrosa, through the Lieutenant Governor of New Mexico. Through the Lieutenant Governor of New Mexico. Directed this document to the White House Oval Office. 1600 Pennsylvania, Washington, D.C. And it was received by the office on July 13 of the year 2021, 2020. Taking that back, 2020. This is going to be one that you're not getting out of Mr. Donald Trump. we have forensic evidence. And all these trespassers are coming with you. To jail, to federal prison for the rest of your life. Because forensic evidence is the maximum proof. Now, we prove, for the Honorable J. Jesús-Arriaga Abonce, that among all these companies, it was sent to the Oval Office, okay, as we said. And now we are going to read all the other places that these documents were sent. Certified mail. To the 13th Judicial District Court, Valencia County, for the record. To Shell Point Mortgage, Shell Point Mortgage also received this notice. And to the United States District Court for the Corporate District of New Mexico, for the Honorable for the Honorable P. Johnson, or for the court, for the clerk, for the court clerk, to direct it to the Chief Judge, P. Johnson. Directed to all state insurance. Are we all on the same page? Because we have this document that we're going to read for the record. For the copy claim and copyright of the personal property. You received this document. I could read it for the record, but I'm going to read it. This one here is going to be for you to read it because everything is in there. And then for you, Mr. For one William Henry Gates III. You also received this document. You received this document. In regard. This went out to the United States. This went out to the United States District Court. It's the People's Exhibit Foxtrot Uniform Juliet Hotel Romeo. United States District Court, District of New Mexico, Office of the Clerk, document summary page. Date February 7, 2020, 11:05 a.m. to J. Jesús-Arriaga Abonce. You're leaving out the column and the hyphen. No, that is not the name. The name has to be to wit. Column. J. Period. column, Jesús, hyphen, Arriaga, column, Avonce. This is not the real name. So to the district court, for the Honorable J. Jesús-Arriaga directed this claim on case 1, column 20 dash Charlie Bravo 00113 dash Juliet Hotel Romeo, document filed Feb 0 column 0207 2020. Please take notice that the United States Magistrate Judge Jerry H. Ritter, or Juliet Echo Romeo Yankee Hotel Capital period Romeo Capital India lowercase Tango lowercase Echo lowercase Romeo lowercase has been assigned for a 28 USC 91915 review. This document was filed also through the Federal Bureau of Violations, or Federal Violation Bureau. In a sworn statement. And this is failure to act up on a constitution, failure to act up, failure to act in a ministerial duty on the witnessing of a constitutional wrong. Mr. Donald J. Trump, President of the United States, now ex-president, because you lost miserably, and you lost on this one too. Here we have evidence that we send a flash, Secretary of Defense, to the Honorable Mark Alexander Miley, and to the Honorable Chairman of the Board for the National American Red Cross. The Honorable Donald John Trump and President for the United States deploy all emergency procedure to restore the right to liberty under the Geneva Conventions for the Honorable J. Period. Column. Jesús. Dash. Arriaga. Column. Avonce. And for the Honorable. Column. Adelina. Hyphen. Arriaga, column, Pedrosa, are not private citizens, are one of the people, pursuant the preamble to the United States Constitution. Prisoners of war, because there is a war. They've been warring against, they've been warned, and they've been given warning after warning after warning, judicial notices, mandatory judicial notices, writs of mandate, as shown on the record. To the time somebody has to point it out to you with a letter of rogatory, you should be ashamed, all of you. A rogatory letter was sent. That's all you need. A rogatory letter and say, hey, Barch, and this is accruing at the tune of $50,000 per day. And that's the equivalent of 10 times the money because no Federal Reserve note this is lawful money. And you're looking at it. You continue with it. This goes to show that forensic evidence on the record, it is the proof of violation of AUSC 5, AUSC 14, equal protection under the law. A violation of 36 CFR /36 U.S. Code 273.1. False and misleading statements on the violation of Title 18, Section 1341 and 1342. In all the titles listed at bridge on the complaint, on the criminal complaint that we just mentioned, and nobody showed up. They couldn't challenge. They wouldn't challenge. I mean, hey, this is an audit. I'm an auditor. For the Honorable J. Jesús-Arriaga Ponce is an auditor in block law. Auditor in Code of Banking Procedure. And it's been written in the documentation several times. Nobody's questioned that back. What is the difference between a citizen and one of the people? And you should know that. Go read the preamble of the United States Constitution. Now, when we for the Honorable J. Jesús-Arriaga Ponce, directed all these documents to the White House, to the superior office, to the maximum superior, to the chief of the armed forces. This is Army. This is armed forces. Intentional sign treasons, conspiracy, violation of Title 18 U.S.C. Section 1516, Section. You know, you can read it here because you got this document. You didn't bother. You say, yeah, what's the problem? Conspiracy violation to Title 18, no problem. And then you run away, Mr. Trump. Donald Trump, this is evidence. You're going to jail. You know, you can bring me Giuliani. You can bring me any of your lawyers. Any lawyer. You can bring me 10 or 100 lawyers. And they will not challenge this document, sir. And they will not. They cannot. This is forensic evidence of treason. Violation of Title 18 U.S. Section 241, conspiracy against rights. You don't know what conspiracy against rights. You were told if you didn't act up on a ministerial duty, you were compounding yourself to the same constitutional wrong. Violation of Title 18 U.S. Code Section 241, conspiracy against rights under color of law, due process violation, want of jurisdiction, and direct contempt on presence of the Superior Court of Record. Plus, the kidnapping of a federal judge because of your nonfeasance for the second time. Nonfeasance, malfeasance, misfeasance. And it was mentioned and it was written, it's on the record. Superior Court of Record. Performing on the Superior Court of Record is hereby sentenced to life without parole. Listen to this. Without parole, the decision of the Superior Court of Record is not reviewable. It is so ordered on 6/17/2020. Now, this goes for the Marshal, the U.S. Marshal. You are also invited to this to perform on a ministerial duty in the witnessing of a constitutional wrong, or be compounded to the same constitutional wrong. For the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa are protected by the Geneva Conventions of August 12, 1949, International Treaty, and Protocol 1 of June 9, 1977. We bothered to put you a copy here. It's the People's Exhibit 1. The People's Exhibit, Free the People 1. Free the people. You don't free the people who you have kidnapped. You don't free the people who you have under attack. For the Honorable J. Jesús-Arriaga has a physical condition where he needs urgent medical care. This is cause hardship, financial hardship to the very agency that looks after the well-being of the military forces throughout the world. Donald Trump, we are at the Peace Palace at The Hague in the International Court, and we have forensic evidence that you have violated knowingly, willfully, maliciously, and intentionally, and negligently, you have violated international treaty. You're going to Guantanamo. All of you trespassers are going to Guantanamo. Chief Justice Roberts, you agree, right? you have to agree, or else we'll get you over there to Guantanamo as well. The Mexican President Andrés Manuel López Obrador has been invited to this in a video and asked to be invited through the Lieutenant Governor of New Mexico, by commission of the Honorable Michelle Vasquez, on the record under the Great Seal of New Mexico, in the Superior Court of Record at 6/17/2020 at 6:29 p.m. And it gives you all the list of all the documents that you received. And we started with the green card, right? Everything is on the green card. You received it, you ignored it, nothing has been done. But hey, you know, it's forensic evidence of your wrongdoing and you willful compounding to this conspiracy, to this treason. Now, in this foreclosure, we had the right to cancel, so we cancel. See, for the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa, cancel this contract or this alleged contract that is not signed by the other party. Cancel on June 19, 2020. June 19, 2020. False and misleading representations, violation of Title 15 U.S. Code Section 1692E, or ECHO, lowercase, violation of Title 15 U.S.C. 1692F1, unfair practices. Unfair and deceiving practices. Now, we place a claim to the Federal Trade Commission, and we have the same reference, the same documents, the same proof that you were given these documents and you have done nothing. It's obvious that it is a conspiracy. Period. And we could go into the detail, but you know, it's going to have to be read into the record for the claimant's knowledge of the life is with the claim by this claimant. Now, this goes for you, Mr. William Henry Gates III. No, not the first, not the second, the third, sir, the third. Who is the second? Can you have a second? Can you have a third without a second? But your father was the first. Where is the second? Or why are you the third? On that, you're bringing a false and misleading information. You cannot have a third without the second. And this was given to us by the Honorable David Wynne Miller, by the Honorable column David Wynne column Miller, Federal Postal Judge sui juris, and one other people. Did you challenge? Did you challenge this? I got a fingerprint. And we got another fingerprint. We have a DNA. We're claiming to be live. Where in the world does your system declares a dead person? Because for the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa, they are not dead. And they're live. They're telling you here is live. Do you deal with live people, sir? Live people are coming to you to make a claim in this claim and this same claim on the international court. And the name of the people and for the people. As contained on the record. We found the glitch. We know what you're doing. You know, it took a while. It took a while to do it. But we found the glitch and we have forensic evidence and it is going to be presented in the same case here. And I'm going to do it here in front of you. Perhaps in this video, if I get a little bit of time, I have a lot of ground to cover. I have a lot of things to emphasize. But this is the one and the most important. William Henry Gates III. You are hereby informed, warned warned and given 72 hours to stop and correct the record, or it will be forensic evidence of contempt of court. It will be forensic evidence that you were given the opportunity to withdraw and you didn't, and you did not. And we hear you got a lot of money, so you are looking at $1 billion per day, sir. $1 billion per day until all matters are resolved in the Superior Court of Record and in the United States Supreme Court for the United States and at the Peace Palace at The Hague, who has a permanent seat at the United Nations Permanent Court of Justice. The same, you're going to bring me your lawyer? Well, the bond requirements on this case, the bond requirements, for those of you who want to bring any controversy, take the time and go and read the bond requirements. But the bond requirements are set at $2.5 million on the replevin. But remember, it's real money. It's real money. It's not bogus trash or bogus garbage as Federal Reserve note. So it's 10 times the money. Because you cannot pay for a crime with bogus money or bogus Federal Reserve note. So it's $25 million on the replevin. For you, peanuts, no problem. But remember, in the performance bond, it's $7.5 million. So we're talking $100 million bond here. If you want to bring some controversy, perhaps you can't bring any controversy. What kind of controversy do you have over this? We talk, we walk, we have our thoughts, we have blood, we bleed, we are creatures of this earth. Uomo, uomini, mammifero vertebrati, not a corporation. So now tell me, Judge Roberts, tell me, Chief Judge, we've sent this document to be confirmed. Document to be confirmed. But maybe you don't need the document. I'm going to give you the question. Is corporate law corporate? Or is corporate law for people? Are people corporations? Are corporations live? Since when corporations are live, sir? Since when? Answer the question. You need to go through the bylaws, correct? To be a corporation? Now, show me the bylaws. That for the Honorable J. Jesús-Arriaga Ponce is a corporation, and that for the Honorable Adelina Arriaga Pedrosa is a corporation. The punctuation means something, sir. And if you don't know it, find out. Go read. Go do some research. Because you knew, or you should have known. You are the connoisseur expert You are sitting on that bench and wearing that dress for a reason. So you agree, right? But if you don't agree, welcome to Guantanamo. Get a hold of these papers. Maybe they are in a bar someplace on Mar-a-Lago, or they are, I don't know, they are someplace in a trunk. And that is forensic evidence of non-feasance. Malfeasance and misfeasance. Non-feasance, malfeasance, and misfeasance. Conclusion. And this was written by hand under an emergency basis. Federal Postal Court on the United States Code, Title 28, Section 636. You must have physical evidence. Words written on paper is a physical evidence of the judge, lawyer, or private citizen is engaged in a fictitious conveyance of language to cause damage to another human right, to another human being under Title 42, 1983. Not 319, 329, 349. Which is policy, custom, and usage. The damage is established under Title 42, Section 1985, subsection 1. It is conspiracy. Two or more persons are said to have conspired to prevent an officer from performing his or her duties when such persons conspire to force, intimidate, or threaten the officer from accepting or holding any office of trust or place of confidence under the United States provisions against conspiracies to interfere with civil rights. Now, Donald Trump, did you act on this? Did you act on this paper, sir? And we told you, if you don't, you'll be conspiring. You will be compounding to this constitutional wrong. If you were coming on an airplane on your jet, and I am in the control tower, and you want permission to land, I will send you in the right way, in the safe way. I certainly wouldn't send you on front of an F-111 that is taking off. You did that exactly to yourself. And we have forensic evidence on the record. Documents, case numbers, law. I don't think I need any more than this. You were informed that this transaction, this mortgage, this is book 12, page 31 in Roman numbers, analysis of law, owned by, for the Honorable J. Period, column, Jesús-Arriaga, column, Abonce, comma, a special master in common law. To be challenged by one Kenneth J. Gonzalez, pseudo-judge, trespasser, corresponder, wrongdoer. Federal judge. You did not act on a ministerial duty, sir. You have not. And because of your malfeasance, your nonfeasance, and your misfeasance, For the Honorable J. Jesús-Arriaga Alonce was kidnapped for the second time on August 13th of the year 2020 while delivering a bench warrant for the arrest of the judge. And all these judges on that warrant, we're going to have an opportunity to read the warrant, but we're going to refer you to it. Item 14, title of ownership, 2 pages. Hey, nobody has challenged this title of property. For the Honorable J. Jesús-Arriaga Alonce and for the Honorable Adelina Arriaga Pedrosa, the undersigned having first been duly sworn upon oath, depose and state the undersigned owns that certain property described as follows: Lot 12, Block 4th, West Wind Subdivision, 29 and 30 Township, 7 North Range 2. There has been no work or labor performed or materials applied or supplied for the improvement of the above described property for which the payment in full has not been made or by which could result in recording or imposition of a lien or claim for payment pursuant section 48-2-1 Echo, lowercase, Tango, lowercase, Sierra, lowercase, Echo, Quebec, period, comma, or 48-2A-18, Sierra, Echo, Quebec, period, comma, November, Michael, Sierra, Alpha, 1978, period. The undersigned agrees to indemnify Albuquerque Title. The undersigned is not to indemnify Albuquerque Title. Albuquerque Title is to indemnify the undersigned. They sold the insurance of title. They say this title is good. And we do so to encourage you. Look. And is underwriter for the claims whatsoever regarding amounts which might be due any person for improvements made on to the property described herein. We further agree to promptly pay and or discharge any such liens or claims. Now I have a lien of foreclosure. They have to come over and discharge it, but these people, Albuquerque Title has not gone out of business, I hear, or it in information and believe is now Wells Fargo. Or in the event any lien is filed, we will promptly procure a release or discharge thereof. Failure to perform under the contract, the violation of Title 641A. You know what? They are not doing their job. Violation of Title 18, Section, U.S. Code Section 641. These are false and misleading representations because now become false since they are not performing under the promise. And you didn't read this, Mr. Donald Trump? You were too busy, you didn't read it? There are no special assessments, utility expansion charges, or similar charges due which have not been disclosed in Albuquerque Title Company. And we do hereby hold Albuquerque Title Company liability commercial should such assessments or charges exist. No petition for relief under the bankruptcy code has been filed by or against the undersigned within the last year, nor is any bankruptcy proceeding currently pending wherein the undersigned is debtor, nor does the undersigned intend to file such petition for the foreseeable future. Corporate that no person or entity occupies the above referenced property in whole or in part, except the undersigned, no person or entity has occupied all any part of the property during the period of which the undersigned said property except following name, for all whom in any or name have permanently vacated said land and claim no rights or interest to said property. If none, state none. There are no unrecorded assessments or claims of assessments known to the undersigned. And this was executed on the 16th day of September 1997. And it was recorded with a certificate of acknowledgement. Now, for the Honorable J. Jesús-Arriaga Ponce, Honorable Member of the Military Welfare Service, sir, please here, listen, you are the president, you're the chairman, you're supposed to come over and do something about this. The National American Red Cross. And this is the affiliation number. Pay attention. It's going to be capital letters and numbers. Alpha, Michael, Romeo, Delta, Michael, X-ray, 0, 2. Alpha, Michael, Romeo, 2, 1, 0, Alpha, Alpha, Charlie, Kilo, X-ray, Alpha, 0, 0, 0, 0, 0, 1, 3, 0, 8. Geneva Conventions, Prisoner of War, Handbook. Today, every member to the United Nations has accepted the Geneva Conventions, making it international law. Violation of international law, sir. For document which was meant to be distributed to prisoners of war. You are warring against those who are the worry about the well-being of your families. You are army, right? You're fighting the welfare of the army. You have. You are. You are. This book was done as a study of the Third Convention, with perhaps a little humor known. And however, as you go through the topics, please keep in mind that many of these things can literally mean the difference between life and death to a prisoner of war. Despicable. For a document which was meant to be distributed to prisoners of war, little or no provisions, familiarity, and then the Geneva Conventions are not very user-friendly. But here's the best part. And it's outlined on page 65 for you for you for the record. And I'm gonna read it for the record. A prisoner, Article General Provisions 1, Article 82. A prisoner of war shall be subject to the laws, regulation, orders, and force in the armed forces of the detaining power. The detaining power shall be justified in taking judicial or disciplinary measures. In respect of any offense committed by a prisoner of war against such laws. What kind of offense has the Honorable J. Jesús-Arriaga Alonce and has the Honorable Adelina Arriaga Alonce has committed against the armed forces? Helping them? Is that an offense? And we are detained. Kidnapped. We've been kidnapped. I sent you an SOS, a flash. You did something about it? No, you didn't. But listen, this is forensic evidence in the record, and you are going to Guantanamo. You cannot challenge, sir. You cannot challenge. It's done. The damage is done. So how many times I will have to say that? The damage is done. You did it knowingly, willfully, intentionally. You enter. We sent you a maritime contract. It's a maritime contract. Regulations or orders, however, no proceedings or punishments contrary to the provisions of their chapter shall be allowed. Okay. Article 40. The wearing of badges of rank and nationality as well or decorations shall be permitted. Badge permitted. And they did not know it. They wouldn't recognize it. They haven't. You know what? In fact, we have somebody here saying, hey, we don't recognize common law. And you are like, really? Final answer? You don't recognize common law? Final answer, sir? It's on the record. You're going to jail. You're going to prison for the rest of your life. Regulations, order, notice, and publication in every in any kind relating to the conduct of prisoners or shall be issued on them in a language which they understand. Article 41, Geneva Conventions, POW Handbook. Have they presented this in a language that it is understood? Where is that paper? This is artificial language, sir. This is artificial language. For all you lawyers and attorneys, you know that you are not writing correctly. Like over here, 3 bankers' trust took title to subject property. Subject property. PRO means no. PER is personal, and ETY is contract. By a deed from the Department of Veterans. Now, how is the Department of Veterans comes into the picture over here? Because the Department of Veterans was offered $2.5 million in lawful money. In other words, we offer for the Honorable J. Jesús-Arriaga Alonce and for the Honorable Adelina Arriaga Pedrosa, offer $25 million for this house. They wouldn't take it. Well, but they were selling it. They were selling it. It's on the market. The house is on the market. The castle is on the market. A building that it is protected by the Geneva Conventions of August 1949. It's on the market by the veterans, by the Department of Veterans. Department of Veterans Affairs, dated February 25th, 1983, and recorded on March 19, 1993. Instrument number 030556, period. 030556. And book 293 on page 8684 in the official record of Valencia County. So now let's get this on the clear, right? Let's see. And we'll go to that document, book 293, A68, instrument number 030556. How do you purchase this building? How was this building purchased? Who paid for it? Did you? Where did the money came from? From what account? We want to see how did you funded the purchase of this castle. And we offer $25 million. You only had to show the contract. Not on the record, sir. Not on the record. Not as of today's video date. But they continue. They continue. They continue the procedure here. It seems to me like everybody is just a robot. They don't read law. They don't understand law. They don't even care about the law. Not the sheriff, not the district attorney, not the president. Not who? What's going on? And today we'll take this opportunity to invite elect President Biden. I will have to get your name complete from your oath. I'm gonna play it in this video, and I am going to leave you with. I am going to put a video now, in where the Honorable Chief Justice has to enforce this contract. The People's Exhibit M5. Enforce the contract under the evidence presented. For now, we're going to start doing the following. I'm going to play another video for you, Chief Justice John G. Roberts, Chief Justice for the United States Court. Get this book, read it. It's in there. We are. For the Honorable J. Jesús-Arriaga and for the Honorable Adelina Arriaga Pedrosa are being kidnapped by the very agencies they devoted their lives to protect. And here is for you, Mr. Trump, and for you, Chief Justice, And after you see the oath that you administered, that it was administered to the former president of the United States, now former president and criminal convicted of a federal mortgage fraud in violation of Title 18, Section 614, 5, what is it? It's on the video. It's on the video that you just seen before me. I hate to say something that I am not quite sure, but I want you to look at the video. And it is, 18514. Title 18, Section 54, U.S. Code Section 514. You know, that's a clear violation. It's on the record now, and there is nothing you can do about it. Absolutely nothing. Now, in this video, you are giving him his oath, but first we have the honor to introduce you with once more with the Honorable Robert Allen Rayluski. We leave you with the video, and this is forensic evidence introduces onto the fact that everything that is going to be mentioned here is entered into the record as forensic evidence. And for the Chief Justice of the United States District Court, of the corporate United States District Court for the corporate, for the District of Corporate New Mexico. You watch this, you agree. If you disagree, Chief Justice, you're going into Guantanamo with them, because that's the way it works.
Hey there, it's Rob Ryder, and today, Trump, Satan's Full House, on January 3rd, 2021. It'd be a wonderful day if on, which is actually a Sunday, and for some reason they are meeting on a Sunday. January 3rd is the day they're supposed to meet in the Congress start the session, unless the previous Congress has chosen a different day by law, and apparently they didn't, so they're going to be meeting on Sunday. It'll be the Lord's Day, so it's a great day to capture all of Satan's little connivers and schemers all in the same place, the same time. They'll be in the Capitol building, just surround it, arrest them all, because there won't be any of them that are qualified to be a representative or a senator, right? From Jump Street, for the first thing they did it wrong. And, if you followed me for any length of time, I've shown this stuff over and over again. But, I'm going to do it one more time. A little more spice here, a few other facts there, put it together. So there isn't really a lot new in here. But I think you'll find it entertaining anyways. So let's begin at the beginning, that the very first law passed by the first Congress, all right, so an act to regulate the time and manner of administering certain oaths, 1 Stat 23, statutes at large, right, 1 Stat 23, was the first law passed by the United States Congress after the ratification of the Constitution. It was signed by President George Washington on June 1st, 1789, and parts of it still remain on the books. Well, there you go, right? What part remains in the books? Well, the part where the oath does, right? But I'll show you that in a second. But this is what the Act said in the very first section then. So be enacted by the Senate and bracketed House of Representatives of the United States of America in Congress assembled, that the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the form following, to wit, I, A, B, in other words, state your name, do solemnly swear or affirm that I will support the Constitution of the United States. Now, you're supposed to pick swear or affirm, obviously, but you get the idea. That's the entire oath right there. Right? And so where the A, B is, well, that's where the person's identification would go. So that's pretty simple, right? And all the persons listed in the 6th Article of the Constitution are supposed to have taken this oath. So we'll see who those are here in just a second. But one of the other, nice little facts that I came across putting this together was in Title II of the United States Code in Section 26, there's a thing called the Role of Representatives Elect. And it says in this section that before the first meeting of the Congress, of each Congress, the clerk of the next preceding House of Representatives shall make a roll of the representatives elect and place thereon the names of those persons, and of such persons only whose credentials show that they were regularly elected in accordance with the laws of their state respectively, or the laws of the United States. In case of a vacancy of the office of clerk, representatives, or absence of the ability of the clerk to discharge duties imposed upon him by law or custom relative to the preparation of the roll of representatives or organization of the House, these duties shall devolve the Sergeant at Arms of the next preceding House of Representatives. Okay, so whoever the clerk is today, right, of the House of Representatives is supposed to be putting together this list of representatives elect from the persons claiming to have been elected in the last election. Okay, so they all have to come with their credentials, right? And I'll show you that, when the credentials they bring, they're using middle initial names and nicknames, and the governor's using the nickname, and the Secretary of State's using the nickname, and right. So it's just a simulated legal process. It's not what it's supposed to be. It's just pretending. So I say it's a counterfeit, right? Well, now we're talking about counterfeits that affect the United States. That would be a crime against the United States. So there's all sorts of crimes. I mean, that's how easy they are to find, right? They're not. These crimes are right in the open. Anyway, so hey, I'm the witness for the United States, Staff Sergeant Robert Allen Radusky, United States Army veteran, aka also known as Rob Ryder. My email address is quarterrecord@aol.com, and my phone number is 616-712-6179. Okay, so a couple more pertinent facts, right? The 6th Article of the Constitution of the United States, in part, it says that the senators and representatives before mentioned, right, those will be the people going to meet in the Capitol here in a few days, the members of the several state legislatures, and all executive and judicial officers, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Well, I think we can all agree that so help me God is a religious test, and so anytime anybody uses that, right, that oath isn't satisfying the 6th Article of the Constitution. But who did it say? Well, you got senators and representatives. Yeah, we know who they are, right? And then we got your members of your state legislature. Well, they're easy enough to find. All executive and judicial officers. Well, that would mean your governor. It would mean Trump, right? Trump is an executive officer. Because this says to support. This is the big thing, to support this Constitution. And as we're going to look right now, that the oath that in the 2nd article doesn't support the Constitution. right? Second article of the Constitution of the United States. Before he enters the execution of his office, he shall take the following oath or affirmation. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. But it did not say support. Preserve, protect, and defend. And so, even if you said, well, that's his presidential oath, that's the oath he has to take. Well, he's also, because he's the president, he becomes the commander-in-chief, and that's a military office. So he'd have to take it for that office. Right? He needs to take the oath in the 6th article. Right? And so the oath in the 6th article, or for the 6th article, see, it has the name, right? IAB. So he would say, I, Donald John Trump, do solemnly swear that I will support the Constitution of the United States. Okay, thank you, sir. You've taken care of the 6th article. We need to take care of the 2nd article, which we should have done first, and I guess we will. But as you can see here, there's no place to put his name, right? So it's not I, Donald John Trump. It's I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. And there is no so help me God. I've shown this before, but it doesn't take long to watch. So let's go watch what happened when Trump did the 2nd article, or 2nd article oath, 4 years ago.
Please raise your right hand and repeat after me. I, Donald John Trump, do solemnly swear
I, Donald John Trump, do solemnly swear
that I will faithfully execute
that I will faithfully execute
the office of President of the United States
the office of President of the United States
and will, to the best of my ability, preserve, protect, and defend
the
Constitution of the United States.
Constitution of the United States.
So help me God.
So help me God.
Congrats.
There you go. So Esquire Roberts, right, had Trump put his name in at the beginning. That disqualified the oath. And then he had him say, so help me God at the end, which disqualified it again. So, Donald John Trump did not take the oath for the 2nd article of the Constitution. So he's not the President of the United States of America. Now, I know this says Office of President of the United States, but in, I still have it all. Hang on a second. Yeah, I just wanted to show this thing right here, right? The Clause 1 says the executive power shall be vested in a President of the United States of America. Okay, well, whenever you see him with a symbol in front of him, it says President of the United States. But the executive power is vested in a President of the United States of America. And he can't have this authority until he takes care of Article 2. Okay. If you went to uscode.house.gov, right, you can find the Office of Law Revision Council, United States Code, where it says United States Code is a consolidation and codification by subject matter of the general and permanent laws of the United States. Well, good enough. Let's start with these people, see what they had to say. All right, so these are, this is basically United States Code. Now I'm going to go look at Title 2 of the United States Code, 2 U.S.C. Chapter 2. Title 2, United States Code, Chapter 2. Organization of Congress. We're just going to talk about oaths of senators, oath of the president, the Senate, presiding officers, oath of speakers. You get the idea. Stuff to do with the oath. But the interesting thing is when you go to this website and look at the code, which is different than other places you could find the code, it gives you all this read between the lines stuff with it, because this is coming from the people that made up the code. It talks about change the name and transfer of functions of committees and officers of the House of Representatives. So the Committee on Armed Forces or Armed Services of the House of Representatives shall be treated as referring to the Committee on National Security of the House of Representatives. Right? Things like that, where they've changed the name for whatever reason. They have all these committees. But then you get down to these offices, right? And it says, any reference in any provision of law enacted before January 4th, 1995, to a function, duty, or authority 1 of the clerk of the House of Representatives shall be treated as referring with respect to that function, duty, or authority to an officer of the House of Representatives exercising that function, duty, or authority as determined by the Committee on House Oversight, which apparently is now called the Committee on House Administration of the House of Representatives. So in other words, the clerk isn't the clerk. The clerk is actually this person that's going to be appointed by some committee. Because there are certain things in these laws that the clerk is supposed to do, and it's been that way since 1791. So obviously that's long before 1995, and Houston, we got a problem. Same with the doorkeeper. Right now, why would they change the doorkeeper's name or who it is, right? But the doorkeeper of the House of Representatives shall be treated as referring with respect to function, duty, or authority to an officer of the House of Representatives exercising that function, duty, or authority as determined by the committee. Same thing, right? Same with the postmaster and so forth. So, just real quick, that place does exist. Here's the Committee on House Administration. And unfortunately, they don't have an email address, or I would be contacting them to get some information on the things I've been trying to get from the clerk, which apparently she's not the clerk. But they also have this other House Committee on Oversight and Reform, so that isn't quite the same name as what they mentioned in the code that we just read. So, maybe they did. Maybe they switched it over here. But my point is, there's the Committee on House Administration. And apparently that's the people that have the, that are acting as the clerk. And as we'll see, it's the clerk that's supposed to put together the list of representatives-elect and check their paperwork before they get to the floor to be sworn in. Well, they're not doing that shit. Okay, so let's start with oaths of senators, right? The oath of office shall be administered by the President of the Senate to each senator who shall be elected previous to his taking his seat. And it talks about RS 28, revised statute number 28, right? Which says RS 28, derived from Act 1 June 1789, which is 1 Stat 23. Right? So this is, saying take the oath that's in 1 Stat 23. Now, as you can see, all these are hyperlinked, so let's just go look at one. That's what I liked about it. Oh, all this stuff is hyperlinked. It takes you to the revised statutes from, 1878. Where it said, the oath of office shall be administered by a president of the Senate to each senator who shall hereafter be elected previous to his taking his seat. It's talking about oath of senators in 1 June 1789, 1, 2, 1P23. So somewhere in there, that means then what today means we call 1 Stat, S-T-A-T, 23. And we'll see it's the same right here for the representatives, because we'll be talking soon about revised statute 30, right? Oath of Speaker of Members. So that's the oath that's in the code that they're supposed to take. But that's not the oath they take. We'll be looking at that soon enough. But, right? Presiding officer of Senate may administer oaths. Or oath of the President of the Senate. Well, okay, when a President of a Senate has not taken oath of office, it shall be administered to him by any member of the Senate. Right, which RS 29, hey, he's got to take the oath that's in 1 Stat 23. So, now we're talking about the Vice President. Right, he had to take this oath in 1 Stat 23. So the senators are supposed to take it, the vice president was supposed to take it, the president has to take it, and none of them have. Going down here, Assistant Secretary of Senate, Dean, Successor in reference to Chief Clerk of the Senate. Okay, I got a person called the Assistant Secretary of the Senate now, who's taken over for a person that used to be called the Chief Clerk of the Senate. Go figure. Okay, oath of Speaker of Members and Delegates. At the first session of Congress, after every general election of representatives, the oath of office shall be administered by any member of the House of Representatives to the Speaker, and by the Speaker to all members and delegates present, and to the clerk previous to entering on any other business, right? Previous to entering on any other business, you have to do this first. And to the members and delegates who afterward appear previous to their taking their seats. In other words, you can't be a member until you've taken the oath. You may be a member-elect if your paperwork is correct, but you're still not a member until you take the oath. And we're talking about the oath of 1 Stat 23. They don't do it. The clerk of the House of Representatives on the 80th and each succeeding Congress shall cause the oath of office, right, the one of 1 Stat 23, to be printed, furnishing 2 copies to each member and delegate who has taken the oath of office in accordance with law, which shall be subscribed in person by the member or delegate, who shall thereupon deliver them to the clerk. But we're not going to the clerk now, because we're going to this, apparently to this other office, whoever the office of the Committee on House Administration has appointed. So that, don't have a lot of time to get answers to these things, and it's a Christmas holiday, but there you go, right? If you want to know who it is, apparently we need to be talking to this committee. Right? Wow. So, 2 of them deliver to the clerk, 1 to be filed in the records of the House of Representatives. Right? So that would mean the clerk should have them. So I should be able to go to the clerk, so I want to see a copy of that oath that guy just did. And the other to be recorded in the Journal of the House and in the Congressional Record. Now, that makes it sound to me like they're supposed to put the damn piece of paper into the record. Right? That these are documents. One document's going to go to the House, the records of the House of Representatives, and the other is supposed to be recorded in the Journal of the House, and in the Congressional Record. And such signed copies or certified copies thereof, or of either of such records thereof, shall be admissible in evidence in any court of the United States, and shall be held conclusive proof of the fact that the signer duly took the oath of office in accordance with law. You want to know if they did it right? Go look at the fucking records. Records of the House of Representatives. Down John Trump. Go see what they put in there. All right, here's that RS-30 again. Well, we know which one that is. That takes you back to 1 Stat 23. Right? It's been derived from the Act of June 1st, 1789, Chapter 1, Subsection 2, 1 Stat 23. Act of February 18th, 1948, added the last 2 paragraphs to provide a way for which members of the House of Representatives can establish by record evidence, right? They keep talking about there's no evidence. Evidence, where's the evidence? The evidence is in the fucking records of the House of Representatives that the member took an oath of office and so became a member, or proved that they didn't. The proof is in the records. So anybody who's in the D.C. area hearing my voice, you got a chance to go down to the, clerk's office and ask them, try to get us a copy of this stuff. Because I didn't find it in the Congressional Record. I mean, to me, they're saying there should be a copy of it in the Congressional Record. Well, you can pull up the Congressional Record online. I can't find it on there. So where the hell is it? Then they got to do the same with the delegate I think that's for the District of Columbia. Right? Roll of representatives. Again, this is the thing that was supposed to be done beforehand by the person that's been appointed by this Committee on House Administration. Right? Before first meeting of each Congress, the clerk of the next preceding House of Representatives. So that's who it should be. But because this was written long before 1996. Right? I mean, this is the last time it may have been done. So what can we say? I'd be asking both of them. Right? Somebody has to have done this. Where's the roll? Shall make a roll of the representatives elect and place thereon the names of those persons and of such persons only whose credentials show that they were regularly elected in accordance with the laws of their state, respectively, or laws of the United States. In the case of vacancy, already read that. Present by confirmation, convene Congress at such other place. Well, down John Trump, why don't you proclaim you're going to just open Congress at Gitmo? Let's just cut out the middleman. Just go open it in Gitmo and leave them there. right? Because they're not going to take that oath. Not only aren't they congressmen, right? They're not even members elect because they didn't do it in their proper name, but they're all guilty of campaign finance fraud because they all took money to be elected to an office that they're not going to take. I thought that was a big thing, this particular one. So, I might one more thing to find out. Yeah, and so we were looking at sections 21 and on, basically, in Title II. But these first sections, the time for election of senators. So, at the regular election held in any state next preceding the expiration of the term for which any senator was elected to represent such state in Congress, at which election a representative of Congress is regularly by law to be chosen. The United States senators from that state shall be elected by the people thereof for a term commencing on the third day of January next thereafter. Okay. It shall be the duty of the executive of the state from which any senator has been chosen to certify his election under the seal of the state to the President of the Senate of the United States. The certificate mentioned in 1A of this title shall be countersigned by the Secretary of State of that state. Well, that sounds simple enough. Let's see what they did, right? Because what's going on here? Oh, it wasn't there. Where's Franken? Here we go. So, Franken isn't in anymore, right? But this is the certificate of election they're talking about, right? To the President of the Senate of the United States from Tim Pauley, which, of course, that's not his full legal name, so that's not the governor. He may be the governor of state of Minnesota, but state of Minnesota is not part of the United States. Minnesota is. I did a video on this stuff with the state of Texas when they tried to open that case in the Supreme Court, and they were told they didn't have any standing because state of Texas isn't in the United States. Texas is. Texas, Texas, Texas. Minnesota, Minnesota, Minnesota. Right? State of Texas was part of the Confederacy back in 1861, so maybe that's what state of Minnesota is. I said state of Texas, right? State of Texas. In that name, state of Texas, in 1861, that Constitution, it was a member of the Confederacy during the Civil War. Right? This certified on the 4th day of November 2008 that Al Franken, right? Now there is nobody named Al Franken. Albert, middle name Franken. But no, they're saying Al Franken. Tim Pauley is saying Al Franken is representing the state of Minnesota. And, they're getting away with this shit. With the seal. Now, is that the proper seal? Is that a counterfeit seal? Because I showed that in Michigan, they're using a counterfeit seal. It's not the proper seal. Right? So, Mark Ritchie, Mark's got a middle name, so none of these people are who they say they are in their official capacity. And nobody named Al Franken was ever a United States senator. He was an imposter of a United States senator. That's the way she rolls. So this is the Michigan election law, which is MCL, Michigan Compiled Laws 168, and then whatever the numbers are afterwards. And it's one of these things that you can do, it's a PDF, thankfully. And my gosh, you can do a word search, and if you put in certificate of election, you start finding a bunch of hits. There's 47 different hits in this law talking about certificates of election. So it's not, just a one-time thing. So presidential electors, right, they had to have a certificate of election. Well, that's the first thing you want to look at then, Trump, is go look at the certificates of election for each of these people. What does it say? As soon as practical, the State Board of Canvassers has, by official canvass, ascertained the result of an election as to the electors of President and Vice President of the United States, the governor shall certify under the seal of the state to the United States Secretary of State, to the United States lowercase Secretary of State, whoever that's supposed to be, the names and addresses of the electors of this state chosen as electors of the President and Vice President of the United States, the governor shall also transmit to each elector chosen as an elector for President and Vice President of the United States a certificate in triplicate under the seal of the state for his or her election. Right? And I bet you when they convene, they got to bring one of their pieces of paper with them. Okay, well, let's just keep going. I'll show you more real quick. Right? The governor and the lieutenant governor, they have to have a certificate of election. I've been looking, I've gotten the oath of office before, but I guess I never really asked for the certificate of election, so I'm going to do that. Secretary of State shall file in his office and preserve the original statement and determination of the board of state canvassers of the result of the election, and shall forthwith execute and cause to be delivered to the persons thereby declared to be elected to the offices of governor and lieutenant governor certificates of election certified by him under the great seal of the state. Hang on, please. Okay, right, so governor has to have one, lieutenant governor has to have one, secretary of state, attorney general, they have to have one. Right, these are certificates that prove that they were, right? United States senator by the governor. It shall be the duty of the governor upon election or appointment of a United States senator to certify his election or appointment to the President of the Senate of the United States. Said certificate shall be under the great seal of the state and countersigned by the Secretary of State, and a copy thereof shall be delivered to the next person or to the person so elected or appointed as United States Senator. Representatives, they got the same gig going on, right? So there you go, right? The Secretary of State. The governor does the alone, it looks like, does the senator, and then the Secretary of State alone does the representative. However, that isn't quite right. They said that on the senator, they had to be countersigned by the Secretary of State. So the governor doesn't look like he's doing the representatives, but they're doing the senators. Well, they're not doing it at all because Al frickin' Franken was supposed to be a senator. Now, again, this is Minnesota. It's not Michigan, but we're using that as an example, right? That this wouldn't work. Because, even today, Gretchen Whitmer is not the governor of Michigan because Gretchen Whitmer is not the woman's name. Her name is Gretchen Esther Whitmer. She could be the governor of Michigan, but that isn't the name she's using. So she's hiding her identity. Well, somebody hiding their identity then is going to, fill out a piece of paper with somebody else hiding their identity to send to the Senate of the United States Congress or President of the United States Senate to tell them this person who's not using their full legal name, using a fictional name, has been elected. What the frick is going on today? Hang on. Yeah, so here, sometime back now, it's getting to be, this is file 1116, so they said. I had tried to open a miscellaneous case in the Southern District of New York. I did a number of videos on this already, right? And but they turned it into a civil case, right? And instead of it being a miscellaneous case. Well, because they made it a civil case, then they want me to pay the $500 filing fee or whatever the hell it is, or sign the paperwork, say you're a pauper. But when you sign that paperwork as a pauper, you give up all your rights. And so I was trying to say, well, no, I'm a veteran. I'm just going to do it as a veteran. And the Rule 40 of the United States Code says, or Rule 40 of Supreme Court rules say that I can file for free. And I had read that the Supreme Court writes the rules for, the district courts and so forth. So it should apply to this court too. That was, I don't overthink these things, right? My biggest thing is I want to make a public record. I know that when I put this in and they put this on, it is now in a frickin' United States District Court for Southern District of New York. Whether they follow it or not, nothing I can do, right? But it doesn't change the fact that it's true. All I can say is I didn't follow the procedure. But I'm pointing out to them these are crimes against the United States. And so, at the end of the day, I don't care if I didn't do it, right? I'm pointing out a crime, and now they are aware, right? So, In this particular case, I was trying to call a pleas of the crown, which was the vehicle to get things done back in the day when you're trying to get business with the king done in England. It was done as pleas of the crown because he didn't go to the court of common pleas. He went to the king's bench. But the king still had to go to court, right? He couldn't just come and take your property, or they had a name for that, the arbitrary use of power or something like that, right? Now, he had to go to court, have his attorney general get him a writ so he could do whatever needed to be done, just like anybody else would. But I was pointed out in this thing, right, that I'll show you the act, right, that this is the wording that should be on the Great Seal, right? Lowercase, Great Seal, State of Michigan, A.D., da-da-da-da. Well, that isn't how they do it. They put it all uppercase, right? But that isn't how it's said to do it. And it's got more words. It says the Great Seal. This just said Great Seal. So the one that they're using is a counterfeit. That's what this whole complaint was about. Right? That there it is, Great Seal, State of Michigan, A.D., whatever. And I put in here, well, here's the Great Seal of the State of Michigan. It's not the same. This one says the, and it's all in uppercase, and the one they're supposed to use is not have the word the, and most of it's in lowercase. Well, there you are. Goes on and on and on. I don't even know I was telling you this now. That phone rang and got me off track a little bit. But anyways, I wanted to show it, so I have. So hang on now. Okay, so we're back now to Title II, United States Code, Section 25, where it talked about copies of the oaths being put in the Journal of the House and in the Congressional Record. So if you've never seen the Congressional Record before, then it's at www.congress.gov, right? Congressional Record. Just Google Congressional Record. You can find it. You can put in all sorts of dates and go back and look at stuff and so forth and so on. And we'll look at a few things that, I'm not, like I said, I haven't found the oaths, but I found other things that are of interest to me. Such as, so this was January 3rd, 2017. Right? So it's been the last time, well, not the last time, 2 times ago. Yeah. Right, but January 17th. Last time senators were put in, or a time the senators were put in. So they're putting in here that I got the Pledge of Allegiance, then the certificates of election, they're being put in, right? And they're using the people's names as Michael Bennett. It was done by John Hinkle-Looper and Wayne W. Williams. Already no good, right? I'm sure that Michael's got a middle name, so that's not his proper name. I got Daniel P. Malloy. Well, that isn't good. Denise or Dennis Merrill. Again, they tend to use names other than people's proper identification, right? And if you're not properly identifying yourself, then there's a problem. Now, there's also a problem with His Excellency, because Excellency is a frickin' title of nobility, isn't it? Right? You call somebody an Excellency. I mean, that's what you call an emperor or a king. All right, Kamala D. Harris. Well, there you go. So there is no Kamala D. Harris, and there's no Edmund G. Brown. Goes on and on and on. But they put all these people in here right on January 3rd, 2017. They put them into the Congressional Record, and then if we look at January 3rd, now this is 2019. I think that's what I did. I went and looked at different years, okay? This is the House of Representatives section of that, where, for those who really want to dig into it, I wish somebody would, that look at it much deeper than I can, right? If you go to this Congressional Research Service, you Google that, you should be able to find it, right? They have this book, The First Day of Congress, a guide to proceedings on the House floor. And they have another one, I believe, for senators. Right? So this tells you all the things they're supposed to do. And then here's the record of what they did, right? Compare the two, see if they're the same. But in here, There's the Pledge of Allegiance, and then the clerk, as directed by law, prepared official roll of the representatives elect. Now, did the clerk of the House do that, or was that the person appointed by the committee that did that? But there they are, and they make this roll, and they put them all on there, and they go through their thing. Now, they're just using last names, right? So you don't know if it's a Mr. or a Mrs. You know, that doesn't identify anybody. Right? That's nobody's identification. Go down here. Where do I want to see? Well, we're going to get to the oath. Okay, swearing in of members. So here we go. First, the Pelosi had to take it, right? Because she's supposed to be the Speaker of the House, right? Do you solemnly swear that you will support and defend the Constitution of the United States against all enemies, foreign and domestic, that you will bear true faith and allegiance the same, and you will take this obligation freely without any mental reservation or purpose based, and that you will faithfully discharge the duties of the office for which you're about to enter? So help me God. Well, that isn't the oath that's for the 6th article, right? They didn't. No I with their name in there, right? So that didn't. That's got to help me God. That's the wrong oath. Well, then we're going to go on, and now she's going to swear in the rest of the people and give them the wrong oath. So, then they're going to go on with their business of their day. Now, I don't know why they did this, but again, this is on the 3rd, and on the 17th, not that many days later, but on a different day, after they adjourned, it's acting like, so now we're shut down for the day, that these oaths of office are, being done now, that the oath of office required by the 6th article of the Constitution of the United States, comma, and as provided by Section 2 of an Act of May 13th, 1884, which is 23 Stat 22, to be administered to members, residents, delegates, the House of Representatives, the text of which is carried in 5 U.S.C. 3331, which now I, with the name in there. So that's not the one that they showed doing the first time. It's still wrong, because it's so help me God, and it's the wrong oath, but, they even did the wrong oath differently. All right, well, they act like they're putting this in here again. And when they get done, then they're going to go and give themselves an oath for access to classified information. So we have people using middle initial names and nicknames and all sorts of shit, pretending to be Congress, that are now going to go take an oath to get state secrets. Well, that should make them a spy. All right, because here, now they got their names going this way, right? Debbie Dingle, Lloyd Doggett, Michael F. Doyle. All these people are going to take another oath so they can go get state secrets. Well, using this alias, right? So I just don't think that's right. What do y'all think? I don't know how they get away with it, but that's the kind of shit we're dealing with. So, again. Okay, so back to the United States Code. This is 5 U.S.C. 3331, Oath of Office. Right, which is in Title 5 is for government organization and employees. Part 3, employees. Subpart B, employment and retention. Chapter 33, examination, selection, and placement. Subchapter 2, oath of office. So this isn't an oath for somebody from Congress to take. This is for an employee of the executive branch to take. I guess it could be for any branch, right? But an employee of the government to take. So an individual, except the president, elected or appointed to an office of honor or profit in the civil service or uniformed services. I don't see how that could include Congress then, right? Not an office of honor or profit, and it's not in the civil service or uniformed service. But anyways, carry on. Shall take the following oath. We already know what the words are, so help me God. This section does not affect other oaths required by law. Well, 1 Stat 23 is another oath required by law. And they're not taking it. Okay, so then they went and did all but the quoted section. is omitted as obsolete. 1757 was originally an alternate oath to the oath prescribed in 1756, which oath was repealed by an act May 13th, 1884, 23-22. So what is all that about? So what's 1557? Whenever any person who is not rendered ineligible to an office by provisions of the 14th Amendment of the Constitution is elected or appointed to an office of honor or trust under the government of the United States and is not able, on account of his participation in late rebellion, to take an oath prescribed in the preceding section, he shall, before entering upon duties of his oath, take this other oath. So this is somebody who was otherwise unqualified to be in the government, could take this oath to be in the government after the Civil War. Right? So, it's not a Civil War oath per se, because the Civil War was already over, but what was the other section it said? Let's go back and look at that. Jeepers creepers. Where are you? Anyways, it said that the one in 1756, which oath was repealed by an act, this state right here. So what's this oath have to say? So again, we're looking at the revised statutes, 1878, provisions, applications, several classes of officers, right? Here's all the different classes of officers. Well, a member of Congress isn't an officer, they're a member of Congress. Right, that was already shown here, right, where the people are going to take the oath that senators and representatives, before mentioned, members of the several state legislatures, and all executive and judicial officers of both the United States and several states. So it's not the senators and representatives. 1756, every person elected or appointed to any office of honor or profit, either in the civil, military, naval services, excepting the president, and persons embraced by the section following, shall, before entering the duties of such office entitled by salary prescribed following oath. I, put your name, do solemnly swear that I have never voluntarily borne arms against the United States since I have been a citizen thereof. That I have voluntary, so this is like an ironclad oath, right, or loyalty oath, right? On and on and on. Well, they got rid of this oath. This isn't the oath that satisfies the 6th article of the Constitution. And the oath they're taking is an oath that's supposed to be used by people who otherwise couldn't work in the government because they had been working for, enemies, foreign and domestic. All right, that's how you became an enemy of the state. They're all acting like we're, part of this other class of people here. The oath of office required by either of these two preceding sections may be taken before any officer who is authorized by the laws of the United States or local municipal law to administer oaths, so forth and so on. But that's not the oath in the 6th article that satisfies the 6th article of the Constitution. Right? The other thing is, nowhere in the 6th article does it say it's a office of honor or profit. Right? They're executive and judicial officers, not an office of honor or profit. So obviously it's the improper oath, right? The only proper oath to take is this one right here. I state your name. You solemnly swear or affirm that I will support the Constitution of the United States. And that needs to be taken by everybody from the president on down to the dog catcher. All these different classes of officers. Right? Because it's the same oath in this act, 1 Stat 23. It says, members of the state legislature and so forth. But just to show you that it's been, covered also by the United States Code. That'd be in Title 4. No, where are we? Title 2. Title 4 states, Section 101, every member of a state legislature and every executive or judicial officer of a state shall, before he proceeds to execute the duties of his office, take an oath in the following form, to wit, I state your name, do solemnly swear that I will support the Constitution of the United States. They even removed your choice of words. You got to say that one, or you don't get to be an officer in the state. Right? So this is what the governor needs to take. The governor is not the governor until the governor takes his oath, and she never took it, so she's not the governor. And if she did take it, she'd have to put her full legal name in there. And as I've shown, with her especially, that I have a copy of the oath that she put in, which is similar to the oath that's required by the Michigan Constitution, but they changed the grammar, so it's not the same. She uses her Gretchen Whitmer, not Gretchen Esther Whitmer, so it's not her. And it was administered by a notary public, which specifically by the laws of Michigan cannot administer an oath to the governor. So there you go, right? It's just one thing after another that's as messed up as can be. And but Trump, they're all, Satan's full house will all be there. They're all going to be there on January 3rd, 2021. Now, like I said, I think you should just go ahead and issue a proclamation and tell them all to meet at Gitmo instead. And you can just leave them there, right? But if they're going to be in the Capitol, well, they'll all be in one place. And they're not going to have proper credentials, right? They're not going to have a certificate of election with their full legal name on it, subscribed by the frickin' Secretary of State or the governor, depending on how it's done, either or both. So there you go. I don't know that I had anything else to tell you all, but I wanted to share this one more time. Let me go check, make sure I got no other little pieces anywhere. Hang on. And just one last little tidbit real quick that I had found this. Who are officers of the United States? Right, this is from 2017. Jennifer L. Mascott. Right, for decades, courts have believed the only officials with significant authority are officers of the United States, subject to the Constitution's Article 2 Appointments Clause requirements. But this standard has proven difficult to apply to major categories of officials, leading to a circuit split this past December over whether certain administrative law judges needed Article 2 appointments. This article challenges whether significant authority is even the proper standard, using two distinctive tools: corpus linguistics, style analysis of the founding era documents, and examination of appointment practices of the Continental Congress. Well, hey, how about we go back and see, our country, our laws and everything are supposed to be done by precedents. What did they do in the first Congress? Right, I know what George Washington did. He kissed the Bible. That was part of the ceremony. Right, this is a Christian nation. You want to be in, you better kiss the Bible. Both strongly suggest the original public meaning of officer is much broader than modern doctrine assumes, encompassing a government official with responsibilities for any ongoing governmental duty. Any governmental official, right? This historic meaning of officer likely would extend to thousands of officials not currently appointed as Article 2 officers, such as tax collectors, disaster relief officials, federal inspectors, custom officials, administrative judges. This conclusion might at first seem destructive to the civil service structure, right? But this article suggests that the core components of the federal hiring system might fairly readily be brought into compliance with Article 2 by amending who exercises final approval to rank candidates and hire them. These feasible but significant changes would restore critical mechanisms for democratic accountability and transparency intended by the framers. Donald John Trump, take the oath. right? They're not taking the oath of 1 Stat 23. They're taking this, this unconstitutional oath that's in 5 U.S.C. 331. But even when they take this oath, they're not taking it right. It's not being recorded properly. I got to show that too. Then I'll be done. Hang on a second. One more thing to show. So this is the form that all, everybody else is filing, right? It's called a standard form, where is it? United States, U.S. Office of Personal Management, standard form 61. So down John Trump, he got a problem with this office because they bifurcated the oath. Even if this was the proper oath, which, this says it's an appointment affidavit, so it's not an oath anyways. I, state your name, right? Should be your full legal name there. Do solemnly swear or affirm that, right? And then they bifurcate it and put in a oath of office. Like this part down here is the oath of office. No, this sentence up here and this is part of the oath. So they bifurcated the oath. Now I've shown, people that have filled these out before, they're using middle initial names and, so forth and so on. It's not being done proper. They don't do anything proper. So, this is just the kinds of things that need to be fixed, and it could start with one fell swoop. Come January 3rd, 2021, when, we could play Trump cards on Satan's Full House. So, Trump, play your cards. We're running out of time. Okay, thank you very much, folks. Y'all have a blessed Christmas, and we'll see where we are after that. Take care. Bye.
Any questions? If you said no, you know. But if you know, then you knew it. If you say yes, it's a loss. You didn't know. And if you didn't know, that's negligence, because you presume and advertise as an attorney at law, as a judge, who doesn't have the oath. You've heard the master, and he told you. And you've seen it on the book. Things get done by the book. If you're flying an A380 and an emergency comes out, you better go to the books and do things by the book. Because if you don't, they'll find you in a pile of rubble, smoke. But if you happen to be a lawyer, or you happen to be a judge, they're going to find you in Guantanamo for the rest of your life. And if you run away, you'll be sending or commuting your sentence to the electric chair. But if this electric chair sounds like a better deal for you, then you don't have to be eating all those potatoes. And you don't want to be there. Because if they find out that you're a judge, the minute that you get in there, that's pretty much a death sentence. Okay, we have something here that we are going to be presenting for the Honorable J. Jesús-Arriaga and for the Honorable Adelina Arriaga Pedrosa. We're going to have a document here, ¿verdad? In September, we filed for the Honorable J. Jesús-Arriaga and for the Honorable Adelina Arriaga Pedrosa filed a letter of rogatory. It is on the video of September 1st, and it was read to the record. This is where we're going to start picking up some speed, because now, if you didn't catch it on the first video, was September 1st, in this case, it's number, go look for it. It's on the very bottom of this. I think this is video 21. We go down to the bottom, you'll find the first video where we read the letter of rogatory, where the plaintiff is bogus. The plaintiff do not exist. The bank do not exist. The lawyer do not exist. The judge do not exist. The language is fictitious and it's a dry dock on land bringing maritime law. Now, maritime law is for water, right? The law of the water and the law of the land. We're going to be introducing a video in the next video. We're gonna be introducing another video where we have proof, and we're gonna give you a lecture on it. But we find that you are kind of like a kindergarten or less, because no, not even that, because I've seen kindergartners, I've seen pre-kinder students who know how to divide, add, and multiply. And for what's going on over here, you don't seem to have any idea of what's going on. That's exactly what you're going to Guantanamo. One thing that I have to bring is a document that it was mutilated and introduced in the record, and this is brought under the seal of a notary. To the attention of Fidelity National Title Insurance Company. For Fidelity National Title Insurance Company, return to 106-3442 Lima, Michael. Lenders Processing Service Company. This document is a forgery. It's been mutilated. This document is supposed to have recording information squares. You want to rewind the video? Go ahead on the first video that you were presented with. Look at this. Look at this section. And there is a square where it has to be recorded, or else if it's not recorded, you cannot even write a security. So this is forgery. They all are. All mortgages are forgery. All mortgages are bogus. All mortgages do not exist. It's a very, very well orchestrated fraud. And we got you on fraud. We got all these trespassers correspondence, okay? Now, this document here says mortgage. And it is on the name of a fictitious entity. Fictitious entities made up by identity theft from fractions from the real name for the Honorable J. Jesús-Arriaga Bonce and for the Honorable Adelina Arriaga Pedrosa. This document does not contain the specifications of the language. Therefore, it's written on artificial language. If you watch our video and you go down and start watching every video, we have a professor, Adrian Polanco, which tells you that the language is artificial. You cannot have real language. Now we have, go watch the video. And then we have Justice Lawrence Thomas telling you don't do that. So Chief Justice Squire Roberts, I'm going to start calling you Squire. Squire Roberts, you need to act up on a ministerial duty in the witnessing of federal mortgage fraud, a constitutional wrong, and the kidnapping of 2 federal judges, sui juris. 2 federal postal judges, sui juris. And you are given in this temporary assignment under Title 28, Section 636, Subchapter Golf, lowercase. And you need to act up on a ministerial duty. And you need to pick up these thieves and then put them behind bars. If you don't do that, you are compounding to the same constitutional wrong. And you will go to Guantanamo with them. And this is this presiding here, this presiding on today's court is on front, or is in the Peace Palace, as we announced on the very beginning of this video. We have 2.5 to 225, 2 hours and a half. This mortgage is bogus. All mortgages are bogus. You cannot challenge. You did not challenge. We filed the rogatory, and this Cindy M. Mercer went to schedule a hearing from Tuesday, 1st day of September 2020 at 9:30 a.m. telephonically. And that's where we started our first video. So you're going to have to go and watch the first video. And I am going to leave you for now with a little bit of something to read so that you can read it. It is the 10 Maxims of Law. And I'm going to give you some time to read it. Because when I come back, if you have questions, you're worthless. If you don't, then you knew it. And you acted maliciously. Malicious prosecution is $1 million under your commercial policy. I wanted to leave it in there. Any questions? If you said yes, you're worthless. You don't know what you're doing. You're showing negligence. If you say no, you know. So you knew it. And you knew it, you continue. Your insurance has no way out. Because this is forensic evidence. It says here that under the laws of commerce, truth is sovereign. Truth is sovereign. But you read the whole 2 pages, right? Could you read it? Do you read English? If you say yes, I'm charging you with perjury. Because all these documents have been written in English, 2nd grade. If you don't read 2nd grade English, maybe you can learn over there on Guantanamo. An affidavit of truth stands as truth. This is on the 10 Maxims of Law. Okay? An unrebutted affidavit stands as truth in commerce. 1. Papa Echo Tango, period, 1 column, 2 5. He who does not deny, admit. He who does not deny, admit. And this goes for you, Mrs. Elizabeth B. Friedenstein or Friedenstein, Elizabeth B. Lowton, or Elizabeth Lowton, Elizabeth Fried, and perhaps a couple of other names. And this is according to www.mylifecom/Elizabeth hyphen Friedenstein slash E echo lowercase 120-181-5709-398. International Relations and Security Network 92-203-9966. So let's see, you got 1, 2, 3, 4, 5, 6 names. Under which name are you conducting this case? And under what authority? You work for a bank. Do the bank exist? You know the difference between ghosts and people? Do you know the difference between citizens and people? Well, the government owns the citizens. The people owns the government. Can you challenge? A sworn statement, 57 pages. 57 pages. Analysis of law, audit, where is stated in the sworn statement. Privacy Act statement, authority. Title 10, U.S. Code Section 301. Title 5, U.S. Code Section 2951. You do read English, right? You got this document, right? This is an affidavit of truth or a sworn statement, okay, to be challenged. Did you challenge, Elizabeth? In the September 1st meeting, in the September 1st conference, and we have the clown that you send instead of coming over to respond for your crime, you send one lawyer or pseudo lawyer that claim did not know how to address this. It's on the record. If you go to the video, the first video of September 1st, she clearly said it. Your Honor, I don't know how to address this. You lose. You lose, and your insurance is watching. Your insurance is watching. Your commercial policy is reachable by your act. Number one, where is your authority? Where is your certificate of authority? Where is your certificate of authority? All documents have to be notarized, correct? None of you has any document filed under a sworn statement, any verified claim, therefore is worthless, and Chief Justice Roberts do agree. Do agree and say, yeah, throw him in jail. Throw him in jail. Now, they also agree, Judge Squire Roberts, for the Honorable J. Jesús-Arriaga Alonso, is a special master in common law, culto, erudito, uomo sapiente, federal postal judge sui juris, auditor in Code of Banking Procedure, international banking, world banking, Vatican banking, ghost banking, virtual transactions, real transactions. You guys are doing conversion. You have no right, you have no authority, you don't have an oath that satisfies the Article 6 of the Constitution. You just heard the master. You want to go against the master? You're going to have to go against his books. And his books are your books, the books that you should be operating under. One of them is very famous. It's called the Constitution. So for the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Alonso, in this first page, are one of the people reserving their rights under UCC 1-308, 1-103.6, or 103, and 1-109. Did you take the time to go and investigate? That's a universal commercial code. Now, in your paper, you say that we're going to read that paper. And you got you for 6 pages. 6 pages of perjury. 6 pages of violation of Title 18, Section 1001. Because you knew, or you should have known, that the Honorable, for the Honorable J. Jesús-Arriaga Alonso and for the Honorable Adelina Arriaga Pedrosa, they requested this documentation in a language, and go look for it. It's in here. I'm not going to read this. You're going to read it. You read it. You read it. Did you challenge? In these documents, Squire Roberts These documents is forensic evidence of the wrongdoings. Everything is being submitted through the Lieutenant Governor to the 13th Judicial District Court, State of New Mexico, County of Valencia, 13th Judicial District Court. And it's got stamps, and it's been dated, signed, notarized. But in your in your 6 pages that you wrote, you accused the Queen for the Honorable Adelina Arriaga Pedrosa and the King for the Honorable J. Jesús-Arriaga Alonce, both federal judges. I wouldn't want to be you. When you're accusing a federal judge of being a terrorist, now you're going to have to prove it. You have 72 hours to do so. And we know you can't because you don't know. You don't know what you're doing. Forensic evidence of malpractice. Tell me the difference. Show me the law. Show me the law. You're a lawyer, right? You advertise as maritime law expert. We sent you a maritime contract. You didn't even know. Did you challenge? Did you withdraw? No. The People's Exhibit M5, with the failure to withdraw immediately, is with the $50,000 fine per day, effectively August 22nd, 2019. If you were reading a document in which you specialize maritime law, you would have withdrawn, but you didn't. And on the Maxims of Law, that's why I left this book here for you for a while, so you could read them. It seems like you're a very slow reader, so I wanted to give you, all of you guys, an unrebutted affidavit stands as truth in commerce. He who does not deny, admit. But you say that she is a terrorist and that he is a terrorist, and now you falsely accuse 2 of the people of being terrorists when you are the terrorist. I don't have 5 names or 6 names. For the Honorable J. Jesús-Arriaga Alonce only has 1 name. For the Honorable Adelina Arriaga Pedrosa only has 1 name. Forensic evidence. Forensic evidence for the record. And we read it into the record. It's read into the record. It is now part of the record. So please tell Squire Roberts, why is it that anyone reserving the right under the Universal Commercial Code 1-308, 103 and 109 could be a terrorist? So if you reserve your rights, you're a terrorist immediately. Terrorist. And I believe you say terrorist on paper. because we're gonna read that nonsense of yours. Because you say that this one here went on for so many pages. Well, we sent you this book to all of you, judges, lawyers, federal judges, all the correspondence trespassers listed in attachment 1 of this criminal complaint. And I'm gonna go let you read it. I'm not gonna read it for you. I'm not your babysitter. You had the opportunity to read and challenge, and you never did. And then on the hearing of September 1st, you can go over and rewind the video until you do make sense of it. But particularly at the answers or the challenge that your colleague, criminal accomplice, came up with. She says, as I indicated. As I indicated? What does cunilingus fellatio has to do here with the case? Go look for indicated in the dictionary. It's fellatio. So what does fellatio has to do? She came over and she challenged this book saying, as I indicated, that's fellatio. Fellatio, whatever you say. For me, house is house. For me, tacos son tacos. For me, taquitos son taquitos. And for me, taquitos son taquitos. You are reading the same word. You will say taquitos. No, it's not taquitos. Tampoco es anything that you say here. We're gonna take this opportunity and address all of these names in a language that you do not understand and see how it feels. What kind of language did you write these documents on? Unspecified. If you go and read the language requirements, it is clear stated that all documents not written on that document will be dismissed without prejudice, so that you can write them on the language that is requested. But if you're not, they are dismissed. First is without, second is with. It's in there. Did you challenge? Did you bring the documents in the language that it was required? What if I tell you that que esta era una muchacha muy ética, perépica, perempempida, peluda pero bien pompuda? Ética, perépica, perempempida, pelada, peluda, pero bien pompuda. Is that who you are? You don't know what it is. It will be hard to say yes, right? Well, okay. Now, you say that for the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Abonce are Jesús-Arriaga and Adelina Arriaga. Well, you got the wrong people. But here is the code. People. Do you deal with people? Live people? You're a corporate. You're a corporate lawyer, correct? Do corporate lawyers have practiced law for people? We knew you didn't. And you know you don't. and you know you're doomed, and you know not to cross that line because your insurance will burn you. You're going to lose your insurance. You're going to lose your liberty. You're going to prison. You're in violation of Title 18641. You're not doing your job. You're getting paid for it. That's misappropriations. And then you are not doing, you're in violation of Title 18, Section 514. That's creating obligation, and here we are given command under Title 28 to the Secret Service because they have jurisdiction. You know, you cannot create any obligation. Now they have jurisdiction, but we're also bringing you the U.S. Marshal, and in this video, one Elizabeth B. Freudenstein, one Elizabeth B. Lawton, one Elizabeth Lawton, one Elizabeth Pride, and two other bogus names is sentenced to life in prison. But you wrote the document. You wrote the document, you sent it in a bogus language. You were warned not to do that. You did. It was dismissed. Dismiss. You cannot bring it over. Well, can you bring it? No, we're not playing. We give you 3 days. We give you the time in there. Did you do it? No, you lose. You want a challenge? Well, bring me your lawyer. Bring me 10 lawyers. Bring me 5 judges. Bring me whoever. Look, there is 3 federal judges that I'm gonna get to it in a while, in a short while. They're in violation of UCC 109.6. which reads, and we read it that one day on September 1st on the record, which reads that the code cannot be read to preclude a common law action. This is a common law action. This is common law. This is common law. You practice common law? No, you don't. Common law is counter law. Common law is common sense. What you do is nonsense. This is common sense. And you say that this is not in your document, you say that it's nonsensical. Now you're going to have to prove it. For example, in this, I mean, if I was a lawyer and somebody sent me this 60 pages, for example, book page 70, the People's Exhibit Alpha 4, 1 of 2, and book page 2 of 2, book page 71, forensic evidence, handwritten note of rejection of the Honorable Adelina Arriaga Pedrosa's proof of evidence stating future rejection in violation of Title 18 U.S. Code Section 1512, comma. U.S. Code Section 2071, California Penal Code 135, reckless disregard of the Honorable Adelina Arriaga Pedrosa's disability to read Babel, clear forensic evidence of discrimination against the Disabilities Act of 1964. So now, is that nonsensical? Final answer? Final answer, yes or no? So the Act of 1964 or violation of AUSC 5 due process, is that how you challenge? You know, yes, the evidence is on the record now. The record show your accomplice saying, Your Honor, I don't know how to address this. At the time, I step in and say, please let the record show that the opposite counsel does not know how to address this. You lose. How is your insurance going to treat you? But you know, you could say, well, I'm going to be out of a job. I'm going to be doing, janitorial work now? Yeah, perhaps maybe you are doing janitorial work on Guantanamo. You are sentenced to what the penal code shows. Squire Roberts, you agree, don't you? Pathetic. Pathetic because, I wanted it to record. I'm a professional. For the Honorable J. Jesús-Arriaga Ponce, Viceroy, a special master in common law appointed by and for the Honorable Avelina Arriaga Pedrosa. Honorable member of the Military Welfare Services. You are military, aren't you? Or you were in the military, didn't you? John R. Chavez, you were in the military, didn't you? Michael J. Doyle, you were in the military, didn't you? So if you come across of a member of the Military Welfare Service, you attack him. So if you come across a Military Welfare Service, you attempt to sell their castle. Squire Roberts. This is fraud. This is fraud. It says, the bank is getting out saying, hey, you know what, I don't have any interest. I'm going to read this little bit for the record here that says the two bankers' trust took title to the subject property. What is property? PRO means no. PER is contract, no personal contract. So they took title to the subject, no personal contract by deed from the Department of Veterans Affairs on February 25th, 1993. Well, for the Honorable J. Jesús-Arriaga Ponce purchased Castle Arriaga or Castel Arriaga in 1991. Where were you in 1991? You had let me see your birthday. Birthday 7/21/81. You were born in 1981. See, for the Honorable J. Jesús-Arriaga Ponce. You witnessed the contract. You did not witness the contract. You don't have any first-hand information. You didn't see it. You were what? How many years old? This is 30 years ago. Do the math. I believe you had 8. So 81 to 91, 10. To 2001, 20. To 2021, you're 41. You were 11 years old. Did you see it? Did you smell it? Did you hear it? Did you see it? In order to testify, you have to have first-hand information. And if you were not there, your accomplice was not there, you don't have any first-hand information. And it is 5 objections. Objection, 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 objection. This counsel has no first-hand information. Pinci versus Pagliaro. This is standing decision by the Supreme Court, by the Supreme Court for the United States. You don't have any first information. You cannot testify. You're disqualified. You don't have you're in violation of 6 CFR 37.3. You're not even using your real name. And we have forensic evidence. So your documents are worthless in an unspecified language. You don't have an oath. You don't have a license to practice. You don't have agency. You don't have standing. You are not. You are not the damaged party. All you have is an accomplice in there. After you say, I don't know how to address this, she should have stopped it right there. Cindy and Mercer, you're worthless because you don't know what you're doing. We have documents. Documents, this is an audit of law. This is case law. This is case law. Whatever happens inside this cases, there's all these cases now is going to be 8 cases that you lost. What are you doing sitting on that bench? February 25th, 1993, and recorded on March 1993. So let's get this clear. The Brunettos come and purchase the castle. First owners. The documents are mutilated. They're not executed. They're undone. And where does this VA comes into picture? I believe in one of those documents says that there is $1 involved in there. And then for the Honorable J. Jesús-Arriaga Abonce purchased this castle, or purchased the castle in Castel-Arriaga in 1991. So in 1991, you were 10 years old, Mrs. Frankenstein. You were not a lawyer. You are not a lawyer. You are an impostor, thief, an agent for the Crown of England and for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa are not collateral for the Vatican. Vatican banking. But if you can prove, bring it down. Show me the law. Sworn statement, un challenge, 60 pages. Going to the United Nations. It's just a matter of time. You are commanded to turn yourself in to the U.S. Marshal Office, first floor, 333 Lomas Boulevard, Albuquerque, New Mexico. If you run, we have Interpol on standby. But first, we have to give you the opportunity to come and turn yourself in, along with all the trespassers, defendants, correspondents listed on attachment 1 of the criminal complaint. What happens when a lawyer gets a criminal complaint filed against him? Well, you lose your license. You can no longer practice. You're a criminal until everything is clear. You just disbar yourself. You knew or should have known, didn't you? You didn't go to school. If you were given the opportunity to withdraw and you don't withdraw, well, then you enter a maritime contract, and that is too sad. You got a copy of it. You did not do anything about it. And now, therefore, we're asking Esquire Roberts to act up in a ministerial duty in the witnessing of a constitutional wrong or compound to it. Come with you to Guantanamo. And we are getting to you, Mr. Ravestick, Mr. Carl W. Ravestick, Carl W. Ravestick, Carl W. Ravestick. Absolutely. Warning. To all counter defendants listed on attachment 1 and all the above cases, and also listed on the criminal complaint case 1, column 20, Charlie Bravo, Charlie Victor, dash 00113, dash Kilo Golf Capital, dash capital letters, Juliet Hotel Romeo. You are hereby compelled to subscribe to the YouTube channel for the Honorable J. column, J, period, hyphen, Jesus, hyphen, Arriaga, column, Abonce, for the criminal video trial in this corporate United States District Court, for the corporate District of New Mexico and the Supreme Court, to the corporate United States and the International Court at the Peace Palace in Hague, Netherlands, who has a permanent seat in front of the United Nations. Failure to subscribe within 72 hours of this notice will render all trespassers, fugitives, and subject to arrest by the United States Marshal's Office and Interpol. You have been served. Must register on the comment section and watch each video presented on the aforementioned channel. It is so ordered on this 3rd day of December of 2020. Have you subscribed? You're a fugitive now, and Interpol is watching. Have you subscribed? I don't see your subscription. You are a fugitive. You just commuted your life sentence into the electric chair. Unless judge or unless Esquire Roberts wants to come with you if he doesn't put you there. For the record. And this is faxed to you, Cindy Mercer. And there is the transmittal. You cannot say you didn't receive it, did you? 5 pages. Thomas M. Sellers, you also got this. Vincent Serafino, you are charged with violation of Part 273.1 of CFR 36/36 U.S. Code Section 271.3. We say we like to do things by the book. We are bringing this. Titles listed on the criminal complaint, and you are in violation of Title 18, Section 1341 and 1342. I shall be with, for the Honorable J. Jesús-Arriaga Avonce, should be with his family. No. He has to do this because of one negligent criminal. Bank of Albuquerque. Jesús-Arriaga, violation, false and misleading statements, violation of Title 15, Section 1692E. This is not the address. This is not the real name. Now, remember the chief in the district court was decided if you don't have the real parties at interest, it cannot even be attempted. Go read it. It's in the criminal complaint. Go get your copies. You said that it was scandalous. If the scandal went over for 60-some pages, or you call it scandal, is it a scandal to reserve your rights under the UCC? Is it a scandal that you cannot read the code to preclude a common law action? Do you practice common law or you practice corporate law? So you don't practice common law, you practice corporate law. You were told. For the Honorable J. Jesús-Arriaga Avonce and for the Honorable Adelina Arriaga Pedrosa, filed an affidavit of truth saying and file the denial of corporate existence. Trespassing. You practice corporate law? Does corporate law apply to the honorable members of the military welfare service? You didn't see that, right? It's in there. You want to say different? And it states here that it has to be on a language The wearing of badges on rank and nationality as well as decorations shall be permitted. That's my badge. That's the badge for the Honorable J. Jesús-Arriaga Once, Honorable Member of the Military Welfare Service. The very agency that looks after your well-being, you're causing financial hardship. And this is forensic evidence. Article 41. Regulations are notices and publications on every kind relating to the conduct of prisoners of war shall be issued to them in a language which they understand. You are at war. You declare war. And then you bring it in a different language. And the day of the hearing, you don't come over. You send somebody else that says, I don't know how to address this. Well, it's in the book. I just read it. Article 41. Article 82 of the same manual, Geneva Conventions, POW Handbook. A prisoner of war shall be subject to the laws, regulation, and others in force in the armed forces of the detaining power. The detaining power shall be justified in taking judicial or disciplinary measures in respect to any offense committed by a prisoner. What kind of offense can you list over here in this process? That for the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Once, what kind of crime was committed? What kind of violation? What kind of... you cannot take any judicial or disciplinary measures in respect of any offense committed by a prisoner of war against such laws, regulations, or orders. However, no proceedings or punishments contrary to the provisions of this chapter should be allowed. Burn it in your mind. Article 82. At this point, you don't need this. No, you don't need it, because in Guantanamo, I'll send you all of this to Guantanamo. Bingo. Bingo, we got you forensic evidence, 6 pages of perjury. Elizabeth B. Frankenstein. What kind of language is this? I don't see the specifications anywhere. Unspecified language. Let me see. And this is what you write. I'm gonna take some time here. So, if you like, pause the video, get a drink, get some coffee, get your books. Bank of Albuquerque, NA. What is NA? NA stands for no. NA, not applicable. Motion to strike defendant's miscellaneous entries. Defendant's miscellaneous entries. Does this look like a miscellaneous entry? It's a sworn statement. It's a sworn statement. On a criminal complaint. So since what, final answer? Miscellaneous entry? Final answer. So you got legal standards to strike a criminal complaint against you for violation of 6 CFR 37.3, violation of Title 18, Section 514, violation of Title 18, Section 614. Comes now plaintiff Bank of Albuquerque. You know, this is a ghost. I don't see the bank. I didn't see it. In fact, there was no bank. You're strike number 2. You're lying. Perjury number 2. And we're going to start writing them down over here. But this is willful. So far, you got 30 years in prison because each one of them carries 15 and 15. And I got $30,000 for the Honorable J. Jesús-Arriaga Alonce and for the Honorable Adelina Arriaga Pedrosa. Perjury 1, NA, not applicable. What kind of language is this? Comes now, Bank of Albuquerque, NA, perjury number 2. 1, 2. Through its undersigned counsel, where is your agency? You didn't bring the agreement, the undersigned counsel. Where is the agency? Where did this bank hire you as an agent to come over and bring the lawsuit? Hereby request the court to strike. You're not talking to Cindy Mercer. You're talking to the Honorable J. Jesús-Arriaga Alonce, Federal Postal Judge Sui. Juris is not going to be stricken. How could it be stricken? Under what grounds? You thought you were talking to her? I opened up my court. And you knew it. You didn't even realize you were in 2 courts. One that was dismissed because of non-compliance in violation of 6 CFR 37.3, violation of Title 4, Section 101. You're doomed. Go read it. Title 4, Section 101. You don't have an oath that satisfies the Article 6 of the Constitution. You don't have a real name. You have 6 different names. Bitch. But that is not your name, correct? I said bitch. Is that your name? Hard to tell, right? With 5 or 6? Well, you don't have a 7th that is saying that, is it? Can you claim? No. Which one is it? Forensic evidence that you're coming over. Hey, you know, you're a thief. Where you been? That you have to hire, that you have to change your name. You know, hookers change their names and thieves. Hereby request the court. What court? There is upper court, superior court, lower court. You were on the lower court. You're asking the superior court of record, or you're asking the lower court? It seems like you're asking the lower court. Well, the judge is not a trier of fact. The judge is not an assistant prosecutor. The judge is not the damaged party. And the judge has no jurisdiction over the Honorable, for the Honorable J. Jesús-Arriaga Alonso, and for the Honorable Adelina Arriaga Pedrosa's venue. And whatever she decided, whatever Cindy M. Mercer, another pirate, decided is hereby returned. Oh, okay, well, you want to go that route? I have a criminal complaint that I can refile, no problem, under common law, under 103.6 of the UCC. 103.6. Go read it. You cannot preclude. You cannot read your code. Your code is not applicable. To strike defendants Jesús-Arriaga, a.k.a. J. period, column, Jesús, hyphen, Arriaga, column, Abonce. Well, now you're being charged with forgery. You're being charged for using a logo that does not belong to you. Can I use Coca-Cola's logo to do business? No, you're doing business by using the logo of a federal judge, calling the judge a defendant, a federal judge a defendant. Final answer. And then here we have forensic evidence that the first two names, Jesús-Arriaga, are fragments stolen from the real name. And one more thing. And I'm doing this for those of you out there that don't know how to attack a lawyer, how to sever his neck, how to pound him, how to poke his eyes with the law, beat him black and blue with the law. The law says, and I'm going to read it. It's here. And I put it in there. That's what I do. I write law. For the Honorable J. Jesús-Arriaga writes law. Inclusio. Inclusio. Take your shot. Okay? Pause the video. And it reads, Incluso unius ex exclusio alterius, the inclusion of one is the exclusion of another. Certain designation of one person is an absolute exclusion of all others. Coke, 5A, Bravo, punto, Burgin, B, Forbes, 293, KY, 456, 169, SW second, 321, 325. You got it? Capital letters. Capital letters. Are you the coroner? Only the coroner can write names in capital letters, but after one fact, the heartbeat must be 0. The breathing must be done. The human being must be dead. So, since when did you kill Jesús-Arriaga? Are you being charged with murder? Since when you kill for the Honorable Adelina Arriaga Pedrosa and you write the name of Adelina Arriaga? This is forensic evidence of identity theft. Theft. What happens if you steal the identity of another? Well, we all know that. That's trespassing. And using it to bring $94,000 into your pocket, well, now you have to return the money plus 3 times on damages. How much is 9 times 3? Mrs. 27,207,000. But it's over 90,000. I believe it's 94, something like that. Okay, well, we'll see it on the document when we get there. And this is capital letters. And then we proceed later on over here. Well, now you have it in proper case. Proper case. And then you have also known. Okay, well, then you have the name for the federal judge. So you put the federal judge here. individually and as an executor of the state of Jesús-Arriaga. Well, you know what? If I am the executor, I'm the appointed agent for the fictitious name, and for the Honorable Adelina Arriaga Pedrosa is also the agent, an appointed agent, representative, executor for the real, for the bogus, for the corporate name, for the all capital name. We file a cess to EKB. You know what the document is? Cess to EKB, the one with life. So this is the one death, the one that died on first page, dead. And then you want to charge the one that it is life. Since when you deal with life corporations, Mrs. Brainstein, Lowton, whatever your name is, you know, you have 5 names here, or 6. I'm gonna bring that into the screen every time I refer to this trespasser, because this way it's on the record. You know, I will find it in a minute. You know who you are, and I'm talking to trespasser, correspondent, wrongdoer, rapist, counsel for Bank of Albuquerque. You don't have an agency, you don't have a license, you don't have standing. Hey, you're using a bogus name, a bogus language. You know what? Judge Robert Lawrence, Judge Lawrence, in one of our videos, I believe it's in the one before this one or 2 videos down. It has to be in a language that everybody knows. And you know, this is not the language. You know, for example, and I'm going to continue because I'm going to pound you blue on this one. I'm going to pound you black and blue because this is, you wrote it, correct? Now you're going to have to fit. You're going to have to go and prove it. Estate of Jesús-Arriaga, Adelina Arriaga, a.k.a. Adelina Arriaga Pedrosa. It doesn't have the first column, so you're out of luck. You know what? And then you're being charged with using the seal of a federal judge to commit perjury, falsifying, bogus, forgery. Arriaga Pedrosa individually as executor of the state of Adelina Arriaga. Are you familiar with UCC 3-402? Can an agent be liable? If American Airlines hires an agent and the agent is negligent and the subject of giving maintenance to the airplanes, the airplane falls off the sky. American Airlines says, well, talk to the agent. And the agent says, hey, I'm not responsible under UCC 3-402. UCC 3-402 is here for the record. UCC 3-402. Whichever you want to go, you're beat up. You want to go and perceive the queen as an agent? You cannot proceed. What if she reserved her rights under UCC 1-308? You cannot proceed. Why? Because UCC 1-103.6 says that you cannot read the code to preclude a common law action, and let alone the fact that it's being brought against you. You want to go on that route, Cindy Mercer? We can dismiss this, but you know what? We're going to have to open the jail we're going to have to open the jails in the entire United States. Because if a criminal can dismiss this and I get to create that law, I free the people in the whole nation. Which way you want to go, Cindy M. Mercer? Now, you're a criminal. Violation of 6 CFR 37.3. violation of Title 4, Section 101, violation of Title 18, Section 614, misappropriations. You get money to do this, to damage? Do you get money from the federal government to go and damage the Queen? To go and damage, President Donald Trump is, or was at this point, is the former president, and it is also the CEO for the Red Cross. You're attacking one of his people. He is also the chief for the United States Armed Forces. Do you think he's going to allow for you to butcher the Queen in violation of standing decision by the United States Supreme Court? Esquire Roberts, this document is heavy with law. There is a standing decision by the Supreme Court in which you are the Chief Justice. So what are you going to do? You're going to say, no, she's fine, all this law that I do, all of this is nonsense? No, you agree, right? You're going to send her to Guantanamo. And you are hereby invited for one John G. Roberts, or Squire Roberts, Chief Justice for the United States Supreme Court. You are hereby invited by one of the people, the Queen, this is Queen's Bench and King's Bench, to perform under your contract an oath and proceed accordingly in the administration of law on the witnessing of a constitutional wrong, or become compounded to the same constitutional wrong. For the Honorable John G. Roberts. For the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Avonce, accept your oath, bind you to it, remind you of a fiduciary duty, and extend immunity, sovereign immunity, while you carry the King's and the Queen's orders. And proceed accordingly in the administration of law, pursuant to your oath and contract, in the witnessing of constitutional wrong. Defendants. Miscellaneous entries, final answer. Miscellaneous entries, final answer. Do you know the difference between a criminal complaint and a sworn statement and a miscellaneous entry? Final answer, miscellaneous entry. Okay. Perjury number 3. So far you got 45 years in jail, and your insurance owes $45,000. Let the record show. And bring me the challenge. Show me the law. Miscellaneous entry filed on December 10, 2019, December 27, 2019, June 3, 2020, due to its redundant, immaterial, impertinent, redundant. Oh. Final answer? December 10th is derogatory. and we get the rogatory. Well, see. See how you challenge that rogatory. Well, we read the rogatory on the video. Of September 1st, but since you didn't come over, you sent an accomplice, and it is on the record. I forget the name, but it is on the record. And your accomplice comes over and say, Your Honor, I don't know how to address this. Did she tell you that? She went back over and said, man, I ran into a special master in common law, and he entered the courtroom, he severed the judge's head, this bar, self this bar, he brings everything here in order, you know, and I say, I don't know how to address this. Boom, you're done. You lose. Over. So December 10, 2019 is dismissed with prejudice, where for the Honorable J. Jesús-Arriaga Ponce and for the Honorable Adelina Arriaga Pedrosa wrote a document that read, we ask to provide all documentation in regard to any authority he may have and to administering the estate and the property for the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Ponce. Nothing on the record. He didn't bring anything, so therefore it's dismissed. So if you don't have any authority, you run into something like, okay, I'm coming over to steal your mother's house or your father's house, or to administer the state. Well, you gotta have some authority. You gotta be mentioned as an executor, as an agent. And the CES 2KB document is clear about that, and it is being filed and recorded in the county in the Valencia County, and it's being filed as part of the record. Miscellaneous entries. Since when a criminal complaint is miscellaneous entry? So somebody files a criminal complaint and you say, oh, it's just a miscellaneous entry? Final answer? Perjury number 4. Can you proceed against an agent and an executor of the state? No. Under UCC, Uniform Commercial Code, section 3-402. Challenge. Go ahead and proceed. Go ahead and hang and continue and go ahead and, hey, nothing that you do is worth anything. Miscellaneous entries filed herein on December 10, 2019. December 27. I can tell you that December 27 is the default judgment. I bring you a challenge. You don't challenge, default. Bam, you lose. You're out. You have to challenge. This is for you to challenge. This is not for one Cindy M. Mercer. The judge is not a trier of fact. The judge is there to administer the law. And you know what? She knew, or she should have known. She would have stopped it right there. Well, forensic evidence of nonfeasance, malfeasance, and misfeasance. Both of you And all these other lawyers that came in there on the same fashion, Now, one bank says, "Hey, I'm out of here." Where does that leave you? Now, have you conducted? You filed the lease pendants without a bond. It's worthless. That's fraud. That's insurance fraud. In commercial, you have to bring the remedy in order, in case you damage the party. And the county clerk shall know that, and they know. They knew or should have known. If they knew it, is willful malpractice. And if they did not know, it's negligence. But there is no bond, no replevin bond, and you're going far, far, far into jail. Because you're a terrorist, a true terrorist. And for calling the queen a terrorist, you don't know what? I hope you realize it's the default judgment, and it states clearly, and we read it into the record. That one day on September 1st, we say, well, we're going to read this into the record. The judge says we are not going to read any documents into the record. Well, you said we. Who is we? What does we mean? Is we is yes for French, in French. So we is yes, and then no. We are, yes are, and then no. Yes are, no read. What kind of language is that, Cindy Mercer? Yes, no, are, read. And I am being kind enough to read this judgment of default. There you go. And it's got the case number. Okay. So it's notice of defendant, notice of default judgment. For the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Abonce, Federal Postal Judges presiding in this Superior Court of Record, P.O. Box 2441, Los Lunas, New Mexico, XXXXX99-898. Claimants versus Bank of Albuquerque, Elizabeth Friedenstein, 5801 Osuna Road, Northeast Suite A103, Albuquerque, New Mexico, 87109. Correspondence. Now you're being chased. You're the chaser. Now you're being chased. Now you were suing. Now you're being proceeded against. Notice of default judgment. Take it into the record. Take it from the record, whatever the date of this default judgment was, 1 J. Jesús-Arriaga Abonce and 1 Adelina Arriaga Pedrosa, petition for entry of default by the notary against Correspondence Bank of Albuquerque, Elizabeth B. Friedenstein, attorney at law, for correspondence failure to rebut claimants' notice of dismissal with prejudice. Claimants rebut claimants' notice of dismissal with prejudice. You didn't have the documents. How could you proceed? Did you show the documents that you had authority to proceed in the administration for the estate of the Queen and the King for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa? Did you have that? Did you furnish that? It's not on the record. So you are proceeding without a jurisdiction, which makes it worse. You're jumping the hoops. You're playing the game you play. You don't know what you're doing. So here, no authority. Wherein claimants demanded a rebuttal by affidavit within 15 days of the receipt of that notice of dismissal with prejudice. You have 15 days. It's usually 72 hours. We allow something for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa, allow for the mailing for the 72 hours, and they gave you a few more days. 15 days. Did you bring it? No. Carl W. Raystick, did you bring it? No. Could you proceed? No. Did you proceed? Yes. Now we have forensic evidence of a willful tort of malpractice. The correspondence has instituted no rebuttal by affidavit, therefore the correspondence has acquiesced, and it is in statutory default. Judgment, the statutory default. Cindy M. Mercer, you didn't see that? If I had a lawyer that fell into the statutory default, boom, judgment for the claimant. Right there, bam. Now, do you want to challenge? How can you challenge? Under what grounds? You're not a trier of fact. You're not the damaged party. And we told you on that video that one day, you hung up. And I kept talking. I kept talking and I kept on the record, and I command you to command all trespasser correspondence listed on attachment 1 to view the full video, because all of you walked out when you hung up. It turned out that the phone was not hung up. You could still hear me, I could still hear you. For the Honorable J. Jesús-Arriaga Alonso and for the Honorable Adelina Arriaga Pedrosa are requesting the entire conversation, audio and video, because we are providing you with the same. It's only fair. You know, so you know what we're talking about, we know what you're talking about, but so far you're losing. You're losing big. You're going to prison for life. They acquiesced. And I read this to the record. I said, no rebuttal affidavit, therefore correspondents have acquiesced in the statutory default. This default notice shall be evidence that J, period, column, Jesús, hyphen, Arriaga, column, Avance, un, column, Adelina, hyphen, Arriaga, column, Pedrosa, are correct on their analysis of law and other inquiries contained within therein by default notice. The correspondence is stopped from any further action against the natural human being. Corporate lawyers do not interact with human beings, and you have. And it's forensic evidence, and that's why you're going to jail. Going to prison for life. If you run, well, electric chair. By your choice, by your own choice. The claimant and is without judicial standing, has no controversy in law or material fact between the parties exist. And is autographed and notarized. Order of default judgment. Default is entered in this action against the correspondent name and the foregoing petition for failure to serve any filed paper as required by law. Did you file it? No. Can you bring it? No. You lose. Certificate of service. One, J, period, column, Jesús, hyphen, Arriaga, column, Avance, and one, Adelina, column, Arriaga, hyphen, Arriaga, column, Pedrosa, hereby certified that a true and correct copy of the petition for this default and default was served by registered mail by the United States Postal Service on this date. And you go and look at the date. June 3rd, 2020, due to is the redundant in material. Final answer? You didn't challenge. You just don't say, oh, this is what, because it's not redundant, it's not redundant, and it's not in material, impertinent, or scandalous matter. It is scandalous what you're doing, yeah. But it's not scandalous that the queen and the king are bringing it in front of you. Well, you got the opportunity to rebut. What a pity. What a shame. I'm laughing in your face for the Honorable J. Jesús-Arriaga. And then you come out over here with some Junter's deed, Redano, Mateo, and Perni scandals matter pursuant to Rule 1. Over here, dash 012 Alpha November Michael Romeo Alpha. That's code. You cannot read your code. Sorry. Oh, people are going to be laughing. This is in front of the world. You got butchered. That's all. In the alternative, plaintiff seeks dismissal of defendant's criminal complaint. Oh, okay. Well, now we talk about a criminal complaint. So if you are doing all this violation of 6 CFR, you violation federal CFR's Code of Federal Rules. You got 4 names, 6 names. And now you're asking for this to be dismissed under some code that cannot even be read to preclude a common law action. What's wrong with you? You're gonna enjoy this video, I'm pretty sure. Criminal complaint against plaintiff for their failure to state a claim pursuant Rule 1-012B6. Final answer. Final answer. Rule 1-02012 Bravo 6 NMRA. So you want this dismissed under Rule 12B6 for failure to state a claim upon which relief can be granted? So you want that rule to work for you. Well, that's exactly the same rule that we read into the record. That's the same rule that we have in the rogatory. So you say, dismiss this under 1206 under 12B 1-012B6. We filed that first for the Honorable J. Jesús-Arriaga once filed to dismiss under Rule 12B6 on December 10th. It's in the rogatory. The rogatory is being read into the record. Please watch the video for September 1st. And we ask for a dismissal on the Rule 12B6. Now, your client do not exist, and here we got something to show you. Because you need one of this. That's why I put it right here. This is something that, you know, you need to get one of these, lady. It is contempt of court to bring a claim on the name of a party that do not exist. Does Bank of Albuquerque exist? Does Bank of America exist? Deutsche Bank exist? Wells Fargo exist? Final answer? Do corporations exist? Do ghosts exist? Fictitious entities exist? You're doomed. You're saying, oh, well, you know, I want you to dismiss that under 12B6. But listen, I filed first for the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa to file under the same. So if the judge wants to dismiss yours was dismissed first in the rogatory. Doesn't work. Doesn't work. Show me the law. seeks dismissal for defendants. Defendants. What's defendants? What is that word? I don't see the king's name or the queen's name in there. Complaint against plaintiff for their failure to stay a claim pursuant. Oh, really? Final answer? Squire Justice knows the books. So let me ask you something, Squire. If I bring a document and say, hey, I want you to dismiss this, I gave her the opportunity to challenge all these 60 pages, but she didn't come over. And now, she comes over and say, well, I want you to dismiss that because I couldn't challenge it. Would you dismiss it, Squire Roberts? No. It doesn't work like that. And if you do, well, then you compound yourself to the same constitutional wrong. Come on! Defendant has filed 3 papers. Oh, 3 papers. Now, they don't have name. 3 papers. I'll show you 3 papers. I'll show you 3 papers. Squire Roberts. Let the record show this is 3 papers. For the record. 1, 2, 3. "57 pages of legal documents, criminal complaint, 3 papers. I'm going to charge you with perjury number 5. So you got 15, 30, 60. You got 75 years in jail now, and you owe $75,000 to insurance. These are not 3 papers. 3 papers, final answer. And they're not called papers, lawyer. Counsel, where did you go to law school? Defendants has filed 3 papers with the court. The first was styled dismissed with prejudice. Well, you're right. So it wasn't a paper. This is a paper. And it's not titled. It's dismissed with prejudice. Why? Because you could not challenge. I said, show me the entire block of documents that you may have in order to be able to administrate or authorized to administer the state for the Honorable J. Jesús-Arriaga or for the Honorable Adelina Arriaga Pedrosa. Can you administer anybody's estate if you don't have any authorization? Did you send it? Carl W. raised it. Did you send it? No, because you don't have it. And that's why it's dismissed. Come on. That's all it takes. Hey, show me your authority. You don't have it? Bam, you're done. Okay. So now, the first is dismissed with prejudice. Okay. The second, here, the defendant has filed 3 papers with the court. The first was titled dismissed with prejudice and filed December 10, 2019. The second was titled Judgment of Default. So since when a lawyer with 6 names in violation of 6 CFR 37.3, violation of Title 401, Title 4, Section 101, comes and asks the judge. Remember, the judge is not a trier of fact. The judge is not the damaged party. The judge has no jurisdiction. We wrote the quo warrant, a writ of quo warranto, and it was not challenged by the judge. We have a writ of quo warranto here. In the case, in the 392 case, the case that ends up on 392, same for all cases. You cannot show any jurisdiction. You cannot show any authority. You do not show any standing, any agency. You don't have a license. You don't have a name. You know what? This is bogus. You do not exist. You're a corporation. You're dealing with one of the people. Two of the people. The second was titled Judgment of Default. Judgment by the notary. We just read it into the record. Rewind the video. Judgment by the notary. Since when you can challenge an agent, a commission by the Lieutenant Governor of New Mexico? Since when? Show me the law! And filed December 27, 2019. December 27, 2019. The third was titled Criminal Complaint. Okay, criminal complaint. Is that a miscellaneous document? So if I have if somebody files a criminal complaint, is a miscellaneous document? Final answer? Perjury number 6. You had 75 years, 80. You got 90 years now, and your insurance owes it has liability for $90,000. It is on the record. Squire Justice Roberts, you agree, don't you? The third was entitled Criminal Complaint. No? I gave you another perjury. And was filed June 3rd, 2020. So when is this filed? When did you file this paper? Well, go to the stenographic. Go to the digital registry. It's in there. It's forensic evidence. June 3rd, 2020. These filings have no merit. Final answer? Now you're going to have to prove that they have no merit. By what standards? By what standards they have no merit? Perjury number 7. Bam! 105 years to jail. These filings have no merit. Asserts frivolous. All frivolous? Final answer? Perjury number 8. Frivolous? In what respect? Did you write it? Did you conduct an analysis of law and present it? Did you challenge this completely? You would have been acquitted. But you didn't even show up. You didn't even show up in federal court. What do you mean? Hey, come over. Oh, I'm not going to federal, but I'm going to ask Cindy M. Mercer, a district court judge, to overturn standing decision by the Supreme Court for the United States. You have that authority? No. Did you show it? Did the judge dismiss it? We're going to get to you, Cindy M. Mercer, because that's evidence. You threw the documents. Say, I'm going to strike this document. Hey, you're striking yourself out of that bench. And you're putting one Cindy M. Mercer in jail for, I believe it's 3 years. 3 years. And you can never hold a position in the government. Hey, you know what? You're an imposter. You're a pirate. Hey, but it's on the record. It's violation of U.S. Code Title 18, Section... Let's get it here on the record. All right. Well, concealment, U.S. Code Section 2071, concealment, removal, or mutilation generally. Whenever willfully and unlawfully whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or with intent to do so, so takes and carries away any record, proceeding, map, book, paper, document, or other filing, or other thing, file, or deposit with the clerk or officer of any court of the United States, or any public office, or any judicial or public officer of the United States shall be fined under this title or imprisoned no more than 3 years or both. Whoever having the custody of any such record, proceeding, map, book, document, paper, or other thing willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the same shall be fined under this title or imprisoned for no more than 3 years or both, and shall forfeit his office and be disqualified from holding any office under the United States as used in this subsection. The term office does not include the office held by any person as a retired officer or the armed forces of the United States. Include. What does that word mean, include? INC stands for corporation. And a vowel and 2 consonants means no. No corporate. Looting. Judging. Lud is judge in British. And ing, well, I hope you know what ing means. So when you write this, including, no corporate contract, judge. No corporate contract, Esquire Roberts. Can they proceed without a contract? How can you practice contract law without a contract? Bam. Bam. How can you practice corporate law or contract law without a contract? The contract makes the law. If there is no contract, there is no law. And we mentioned that on that meeting, on that hearing, the telephonic hearing, on the video September 1 of 2020. Can you practice contract law without a contract? No. Look at the case of the Erie Railroad Road case. The Erie Railroad Road case. Erie Railroad Road case. No contract. December 27 of frivolous sovereign citizen. Oh, you're going to suffer on this one. Frivolous? Well, they're not frivolous. You are in violation of federal law to begin with. So, hey. So far, you got 105 years. Let me see. 1, 2, 3, 4, 5, 6, 7, 8. 8 times 15. Let's see. 30, 16, 90. 120 years you got so far on this. Perjury. Willful perjury. Sovereign citizen. What is a sovereign citizen? Are you familiar with Chilson versus Georgia? We've introduced that video in this. You have to go down and look for it. It's in there. Chilson versus Georgia. Or Well, just go and look for it, right? We have it on video. We placed that video. We have it here on the record. Standing decision, right? Squire Roberts. Sovereign citizen. You cannot have sovereign citizen. You have to go watch the video for the honorable William Thornton, and he's got a video that's this citizens versus people. Remember, the government owns the citizens. The people owns the government. Tell me different. Show me the law. You agree? Squire Roberts, don't you? It is standing law, standing decision by the Supreme Court for the United States, on which you are the Chief Justice, Squire Roberts. So you have to agree, right? Unless you want to go over to Guantanamo Bay with all these trespassers, correspondence rapists. So, okay, if the government owns the citizens and the people owns the government, and for the Honorable Adelina Arriaga Pedrosa is one of the people, she owns the government. And for a citizen to be owned by the government, and for the Honorable Adelina Arriaga Pedrosa is not a citizen of any country, how is that a prosecution can take place? But you knew, or you should have known. Because that's what it is. If you knew, is willful tort of malpractice. If you did not know, that's negligence. BAM! You're done. Sovereign citizen. Okay, so there is no such thing. You're bringing false and misleading information or false and misleading representations into the record, because there is no such thing. You are referring to a slave master, and there is no slave master, because people are master, citizens are slave, people own the government own the people. So if the government owns the people, the citizens are the slaves for the government, but the people is not. Can you tell different? Show me the law. Now, Cindy M. Mercer, did you forget that part over on the school? Where did you go to lawyer school? Where did you go to judge school, Cindy M. Mercer? Sovereign citizen, legal theories, and should be stricken from the record. Now we're going to go to the UCC 1-308 here, first page. UCC 1-308. Very nice, readable. Red stamp. Universal Commercial Code 1-308, 1-103.6 and 109. Sovereign sitting legal theories? Final answer? No? 15 years more to the slammer. Perjury number 9. You cannot have a slave master or a master slave. That's what it is. Go and read it. Okay. you should have done your research. Now you're bringing false information and misleading representations into the record in violation of Title 18, Title 15, Section 1692E. Carries $25 million penalty, and it puts you in jail for 30. So we're gonna give you that 30 over here, okay, 30, and then we're gonna put you up $25 million here. So for you, Squire Justice, we're gonna be doing some numbers, okay? 25 million. But remember, it's $25 million in lawful money, so that's 250 million. Because no bogus Federal Reserve garbage, you cannot commit a crime and then go and pay with that. No, you can't. But if you can bring it to me, well, just bring it. We'll look at it. I know you can't. You will never find it. You're going to die looking for it, that's for sure. All right. Should be stricken from the record. Should be stricken from the record. Okay. So you're saying you want to stricken from the record something that is being filed you couldn't challenge. For the Honorable Adelina, for the Honorable column, Adelina, hyphen, Arriaga, column, Pedrosa, is one of the people, not a citizen. So now you want to declare the Queen as a citizen? That's a perjury. Final answer? Perjury number 10. Man, you got 150 years plus 30. You know, it's 180 years. You're not getting out. Legal standard for a motion to strike. Courts may properly strike from the record any insufficient defense. All right. Is 1-308 insufficient? Ha! Insufficient. If the Uniform Commercial Code is insufficient by your statements here, now another perjury, 11, you're bringing false and misleading information, presentations into the record. Final answer? Insufficient defense. So you're not in violation of 6 CFR 37.3. You're not in violation of Title 4, Section 101. You're not in violation of 1 Stat 23, Section 1 of Page 1. You're not. You got another 15 years. At this point, I could stop reading this document, but we haven't gotten one page. And I'm going to continue. Courts may strike properly from the record any insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Is it scandalous to reserve your rights under the UCC 1-308, 103.6, and 109? 109, go find out what's 09. It's private property. You cannot get into private property. Do you own this property? No, you don't. How was it purchased? Where did you get the money to purchase? Bank of Albuquerque, how did you purchase Jesús-Arriaga? Show me the proof. Show me where did you get this money from? Show where the money came from. And how was disbursed? You're talking money, not federal note. Federal Reserve note is not money. And by the way, this is complaint for foreclosure and money. Complaint for foreclosure. We got one page. You got 150. You got 165 years in this page plus 30. Got 195 years. in one page. Remember, we still have to read page number 2, page number 3. And we're going to sit here and read it. Because we got time. And you got time. And we are in a court, in an open court under Title 28. But you know, I'm gonna finish this page. This page, legal standard for a motion to strike. This is false and misleading representations into the record because reserving your rights under the UCC 1-308 is not insufficient defense. Is it? Insufficient defense? Final answer? Final answer. Answer yes or no. Is it insufficient to reserve your rights under the UC 1-308? Okay, now we, in the first video, we started with that, reservation of rights. And we said, how can you, see, if you are operating under common law, if you honor common law, and you operating under UCC, how is it that the UCC is good for you and bad for the queen and king? No. The queen and the king, for the Honorable J. Jesús-Arriaga once and for the Honorable Adelina Arriaga Pedrosa, reserve their rights under the UCC. They have exercised that remedy, and it was read into the record. And you cannot proceed or read code to preclude a common law action, criminal action against all trespassers correspondence listed in attachment 1. Squire Roberts, you agree? I take it as a yes. Because if you say no, you are compounding to the same constitutional wrong. What is this code here? No code, no statute under common law jurisdiction, common law procedure, the law of the republic. Can't bring me any difference. All this code is hereby rejected. The court find it improper to strike a brief or plaintiff from the record on the grounds that it was not embraced among papers regularly. Oh, really? Final answer? Plaintiff from the record on the grounds that it was not embraced among papers regularly. Filed in this case with the clerk of the district court as defined. No? Final answer? You were asking to dismiss these documents from being filed on let me see, August 30th of 2020. The stamp is in there. You're going for another 15 years. You're going in for another 15 years. And we're going to read this in a minute. I hope we got time, you know. Perjury number 12. Perjury number 12. To include. What does include means? INC is a corporation. LUD is judge in British. And what is DE? DE means no. In means no. So you got two no's and two no. You got no judge to no judge. Only such papers which by statute or rule, no code, no statute under common law. Perjury number 13. Perjury number 13. or rule or order of court are required to direct to be filed internal quotes and citations omitted. What is this? What is internal? In means no. T-E-R is terra. No terra. What is null? N-A-L. And citation omitted. Two defendants' filings are redundant, immaterial, impertinent, illegally insufficient, and scandalous. Perjury. Defendants' filings are immaterial, impertinent, legally insufficient, and scandalous. Perjury 1, 2, 3, 4, 5. You got 5 perjuries here, ma'am. So another 5 perjuries is going to be hasta el 18, 14, 15, 16, 17, 18. You got 18 perjuries so far here, and we haven't reached middle page 2. Defendants' filings are redundant, immaterial, impertinent, legally insufficient, and scandalous. Final answer? They're not. For Judge Roberts, for Squire Roberts at Supreme Court for the United States. 57 pages. Loaded, heavy, with an analysis about it of law, standing decision by the Supreme Court for the United States. She's calling it Mrs. Counsel Elizabeth B. Friedenstein, Elizabeth B. Lawton, Elizabeth Fried. Is saying that your decision of the Supreme Court of Justice, the Supreme Court for the United States, is immaterial, impertinent, legally insufficient, and scandalous. You agree that it is not, Squire Roberts, is it? The threats expounded at length in defendants' filings are characteristic of the sovereign citizen movement. Sovereign citizen, final answer? You're either sovereign or you're a citizen. Remember, government is on the middle. Sovereign owns the government. And slave is owned by government. Now you're going to have to prove that the queen is a slave for the government or collateral for the Vatican. We'll never be able to do that. But you know what? You just turned yourself another 15 years. The filings shall not only be stricken. Okay, now you don't want it stricken. Shall not only be stricken, but justify a court order prohibiting defendant to proceeding. Oh, now you're gonna suffer on this one. This is gonna be painful for you. Okay, the filings shall not only be stricken, but justify a court order prohibiting defendants from proceeding. Oh, no. So if anybody that is reserving their rights under the UCC 1-308, 103.6, and 1-109 gives this court gives the inferior court The arguments and threats, they're not arguments, they're not threats, expounded at length. Defendant's filings are characteristic of the sovereign citizen movement. Well, you're done on that one. The filings shall not only be strict and justified, a court order prohibiting defendant from proceeding. Okay, well, you're gonna justify this? So if anybody reserves their rights and refuse to perform under any kind of contract, under any kind of invisible contract, or silence jurisdiction, does that give the court? Because, hey, you got another 15 years. It doesn't give it. 19 perjuries. 19. A court order prohibiting, okay, well, PRO means no. Prohibiting, what is prohibiting? Defendant from proceeding pro se. Okay, pro means no, and se is to say. No say. Pro se. Pro se is, PRO is no. SE is to say. How can anybody proceed by not saying anything? And under what code will anybody be precluded from presenting adequate defense in writing? 15 years more. Perjury number 20. So far you got 330 years and $25 million. PRO means no. SE means is to say. So proceeding, PRO, no ceding, no sé. Oh, no sé in Spanish is I don't know. The defendants claim the current sitting judge and plaintiff's undersigned counsel are using false identities. Of course you are. You're using false identity. How many names do you have? What is the name on your documentation from the Oklahoma University? Because Oklahoma University, where is that paper? Is that the name? Which one of those 6 names is in there? Final answer? You saying you're not? Yes, you are. Perjury 21. Misbehaving. Okay, yeah. Are disobedient. Yeah, you're disobedient of the federal law. 6 CFR 37.3. Title 4, Section 101. And 1 Stat 23, page 1. Section 1 of page 1. So perjury number 22. Resisting commands and are violating the defendant's rights. Absolutely. So if the rights are reserved over here under 1-1, the Uniform Commercial Code 1-308, 103.6, and 109, final answer. Final answer. No? Okay. Perjury number 23. Who are also the real judges will prove it. You are saying we are not. We are saying that for the Honorable J. Jesús-Arriaga Ponce and for the Honorable Adelina Arriaga Pedrosa are not federal judges of the Superior Court of Record. Final answer. In a common law, in a common law action, remember, the lawyer does not practice common law. The judge is not a trier of fact or an assistant prosecutor. In the absence, in a common law procedure, an action, common law action, procedure. In the absence of a jury, the claimant is the judge, becomes the judge. Did you all requested a jury? Is there a jury on the record? No. So yes, this is King's Bench, and for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa are federal postal judges, sui juris, and one other people. Did anybody bring it different? Well, you're saying here they were not, who are all rights, defendants' rights, who are also the real judges of this court. Which court? There's two courts, lower court and this superior court of record. Two courts. You're not being specific. You're lying. Perjury number 24. Because Esquire Roberts will agree, correct? Show me the law. See page 2. Offense description and the facts presented in the criminal complaint filed June 3rd, 2020. The defendants go on to allege that their rights are first infringe the defendants. Now you're talking about some type of defendants. We got claimants and you got defendants. If you are referring to Jesús-Arriaga and Adelina Arriaga, that's defendants. That's the bogus, fictitious legal entity created by stealing and by the identity theft. Those are defendants. Those are the written with capital letters. Those are the dead corporations. Those are the non-existent. By the way, under what authority are you authorized to advertise a you are Mrs. Elizabeth B. Freudenstein or Elizabeth B. Lawton or Elizabeth Fry or Elizabeth whatever your name is. The defendants. DEF is hearing impaired, END is the end of it, and ANTS is ants. For the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa are not ants. Perjury number 25. You're not getting out of jail, I'll tell you that much. The defendants go on to allege that their rights are further infringed. Well, prove different. They're not. So if you reserve your rights under the UC 1-308, you can no longer proceed. And under UCC 1-103.6, you cannot read the code to preclude a common law action. You just earn yourself another 15 years. Perjury number 26. They're infringed by Cindy M. Mercer, and instead invite Judge Jerry H. Ritter, Judge Kenneth J. Gonzalez, and Judge John Robin Hart to serve and witness the constitutional wrongs being committed. Right? They were invited to act upon a ministerial duty and the witnessing of a constitutional wrong. You are right. So a federal judge comes over here, finds a judge in violation of Title 4, Section 101, 1 Stat 23, Section 1 of page 1. In 6 CFR 37.3, he has to act. The federal judge has to say, now wait a minute, well, they did not act. And therefore, for the Honorable J. Jesús-Arriaga Abonce was kidnapped for the second time while he was delivering, while the Honorable was delivering a bench warrant in the 13th Judicial District Court without a warrant, without charges, without proof of anything. It's on the record. For the Honorable J. Jesús-Arriaga once was tortured at the University Hospital in New Mexico. He was stuck a needle under his finger and between the finger and the fingernail. That's torture. You know the penalty for torturing a federal judge? Kidnap and torture of a federal judge, and you are an accessory to it? And these three judges, Jerry H. Ritter, Judge Kenneth J. Gonzalez, and John Rovenhart, are guilty. Self-compounded, voluntarily compounding to the same constitutional wrong, since they did not act up on a ministerial duty, upon witnessing a constitutional wrong. To save and witness the constitutional wrong was committed. Well, they are. If I am a policeman, somebody comes over and say they're raping my daughter, I go and see it and I do nothing, I become compounded to the same wrong. So for the Honorable J. Jesús-Arriaga once and for the Honorable Adelina Arriaga Pedrosa, file, they say, hey, look what they're doing. Look, they're doing this, and this, and this, and this here. And they say, we are not going to act. Committed. Include plaintiff's attorney working for a fictitious bank. Yeah, is your bank real? Final answer? Perjury number 27. Corporations do not exist. They're a fictitious entity, and therefore you are lying. Bringing false and misleading information or misleading representations into the record. In violation of Title 15, Section 1692E. And also, another $25 million and another 30 years in jail. Is your bank fictitious or real? Final answer is fictitious. You're claiming here for it to be real. Perjury number 28. Other wrongs include Judge Mercer, Plaintiff's Counsel, and Carl Reiftek as CEO for the court, forcing the defendants to use false identifications, and their names are legal fictions. Absolutely. Absolutely. It's in the complaint. If your name is Cindy Mercer, you are missing the M, whatever that M is for. If you are Elizabeth B. Friedenstein, you cannot be Elizabeth Fry. Two different names. So, another perjury, 29. See page 6 of the criminal complaint. We'll go and see page 6 of the criminal complaint. Go and see page 6 of the criminal complaint. That's pretty fun. Now, page 6 of the criminal complaint. You all have it. Go read it. Challenge it. But it's over. You didn't challenge. You cannot challenge at this point. This is not a game. This is not a joke. You have to follow the rules. I bring you a challenge. You got 3 days to answer no. Bam. Out. The documents claim the current sitting judge and plaintiff's undersigned counsel are using false identities. Yes, you are. Misbehaving. Yes, you are. Disobedient. Yes, you are. Resisting commands. Yes, you are. Are in violation and are violating the defendant's rights. Absolutely. Who's the defendant? Now you know the defendant has rights, right? Go read 1-308, UCC 1-308. Go read it until you get blue in the face. And if you cannot read it, well, hey, you went to university, you went to school, right? Then we are the real judges. Infringes by rights, yeah. Infringe, okay. Infringement of rights. False advertisement of a corporate entity without the bylaws. Identity theft. Fabricating a bogus or fictitious legal entity with fractions of the real name for the real human being. Judge Jerry H. Ritter wrote, if you don't have the real name or the real address, the process cannot even be attempted. Go read it. You want to go against Ritter's? Go for it. Go challenge Ritter. Hey, he's the one that said it. Can you? Besides, according Black's Law Dictionary, 4th edition, it is contempt of court to bring claims on to a fictitious entity. It's Bank of Albuquerque is a real entity. Final answer. Is it real? It's not. Perjury number 30. It's each count. You say it now, you say it later. Another count. You can say it 10 times. I'll charge you with 10 perjuries. That's how it works. Man, you got 30 perjuries, 30 times 15. You got 450 years by now, plus you got another 30, another 60. You got 430 plus 60. Man, you got 490 years. And we are on page 2. Yeah. This is real court, real people, real claim happening in real time for real violations by a lawyer, a thief. Hey, you wrote this, didn't you? Perjury. Defendant's rights, violating the who are also the real judges on this court. Of course. See page 2, offense description. Offense description, go and read it. And the facts presented on the criminal complaint file, June 3rd, 2020. The defendants go on to allege that their rights are further infringed by Judge Mercer and instead invites Jerry H. Ritter and Judge Kenneth J. Gonzalez and John Robinhart to serve as witness. Absolutely. And witness the constitutional wrong being committed. It is against the Constitution. Tell me it's not. Show me the law. Did you challenge? Every single claim has to be challenged in writing, supported by existing law. Is for the findings on the fact and the conclusion of equitable law. They didn't show you that on the university. Obviously, they didn't. For the Honorable J. Jesús-Arriaga Once, auditor in bluff law. Graduate. Uomo, sapiente, culto, erudito. Federal postal judge sui juris. One of the people. Mammifero vertebrati. Is Mammifero Vertebrati Corporation? No. Mammifero Vertebrati. And one of the people. Does Congress make luck for people? Not a chance. Does it? Esquire Roberts, does Congress make law for the people? Final answer. If you said no, you're correct. If you said yes, you are not correct. And you are compounding. It's on the book. Go read it. Those books you got over there just for show. Because it's obvious you haven't opened that book. So yes, constitutional wrong. Other wrongs include Judge Mercer, plaintiff's counsel, Carl Raystick as CEO for the court, forcing the defendants to use false identifications as their name are legal fictions. Absolutely. Final answer? Another perjury. 31. See page 6 in the criminal complaint filed on June 3rd, 2020. Defendants continue to allege that they, in their capacity as true judges in this court, have issued bench warrants with bonds to be set at $2.5 million. Absolutely. But remember, $2.5 million in lawful money is not that we stated that we want $2.5 million in Federal Reserve note. Because Federal Reserve note is vapor money, colorable law for colorable money since 1933. The only thing that you are missing here is the fact that you are getting real people and turning them into corporations through a system that is designed by none other than William Henry Gates III. Under what authority, sir, can you corporatize somebody or make it subject to corporate law? You are liable. David Wynn Miller advised you to remove it. You did not. It's on the record. And I have the video. You were told, Bill Gates, don't do that, man. That's pretty low, you know. I will have millions of dollars if I went in that route, but I will be infringing on people's rights by turning people into corporations without their consent by your software. It took a while. It took a team of experts, but we sat over there and we looked at it. And we say, hey, here it is. Now, guess what? You don't have any money. You only have bogus Federal Reserve note. And when you get sued for real money, your money is suddenly 10 times less than what you have. Because to buy $1 silver dollar, which is lawful money, minted by the United States Treasury, you have to use 10 bogus garbage Federal Reserve note in exchange. It's not redeemable for gold and silver. And you should know it. Bill Gates, you're going to Guantanamo. Bill Gates, for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina P. Arriaga Pedrosa, are claiming for you for one William Henry Gates the third to withdraw, to fix it, or continue to pay $1 billion in lawful money minted by the United States Treasury until all matters are resolved in this court of record. So that's not infringement. What is, Mrs. Lowton? Opposing counsel, perjury number 32. And we are on page 2. Man. Wrongs committed include plaintiff's attorney working for a fictitious bank, of course. Other wrongs include Judge Mercer, plaintiff's counsel Carl W. Restif, as CEO of this court, forcing the defendants to file identification. Thank you for mentioning that. But who are you? Are you a counsel for the W. Restif, for Carl W. Restif? No, you're not. You are not placed the bond. So your document here is rejected. No bond. You're going to bring controversy? Hey, you post the bond. You don't post the bond, you didn't bring any controversy, or whatever you brought is dismissed hereby because of failure to comply with the bond requirements of this superior court of record. And it's $2.5 million on the replevin, is $7.5 million on the performance. And obviously you have a very poor performance. Poor performance. I own. For the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa, own this much money from your insurance, from the federal government. Yes, they are using, and using it or not, perjury number 33. Okay, perjury number 33, that will be willful perjury. For the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa, filed in the default judgment that a bench warrant will be issued. Nobody opposed. No opposition, no challenge. They say, well, do it. Well, we're done. It's done. It's done. And it's effective. You are commanded. The U.S. Court, the U.S. Marshal, you are commanded and given a special assignment to arrest all these trespassers under the facts presented herein. It's on the record. Proceed according to your oath and contract or become compounded to the same constitutional wrong. Under Title 28, Section 636, Subchapter Gov. This is a court of correctness, and you are all wrong, and this is all correct. Oh, all references in the documents are additionally confusing and incomprehensible. Final answer, confusing. You are confused. You are a lawyer who went to a university to study maritime law, and now you are confused. That shows negligence. You don't know what you're doing. You are confused. Incomprehensible. You don't comprehend. You don't comprehend what is being presented to you. For starters, you don't comprehend that for the Honorable J. Jesús-Arriaga Once and for the Honorable Adelina Arriaga Pedrosa are one of the people. You don't comprehend that part. You want to force corporate status on them? Well, perjury number 34. There are specific pages that are irrelevant and scandalous. Final answer? Which pages? Which pages exactly, and by what means, under what grounds? These are supported by existing law. You don't present a challenge, you present a comment or an allegation. Therefore, you're lying. is another perjury. You did not challenge. Clear proof of evidence is here contained on the record. Irrelevant and scandalous. Final answer? Perjury number 35. Including page 12 that alleged Judge Mercer is a trespasser, Judge James Lawrence Sanchez is a trespasser, and the list continues. You are saying that the Judge Mercer is not a trespasser, and you're saying that Judge Lawrence Sanchez is not a trespasser. Final answer. I'm going to give you 2 perjuries, 1 for each statement. So now you got another 30 years, another 2. Perjury number 36 and perjury number 37. You are not defense for these judges. Since when an opposed counsel is going to defend the judge or a federal judge? You're not defending a federal judge. You are compounding to the same constitutional wrong. And you should know it. If you knew, you are being negligent. It's willful tort of malpractice. If you did not know, that's negligence. And the list continues. Absolutely. Self-executing contracts against other judges? Absolutely. This is a self-executing contract. If you don't challenge, bam, you lose. At this point, we're going to take a break. This is going to be called Section 1. Section 1, well, we're going to keep it on sequence. Keep a number on these videos, okay? And then we're going to continue. I am allowing a break, and I perhaps will continue here shortly. This video is 5 hours and 6 minutes. I'm going to stop it now, and I will continue because we're going to get to this today. This day is going to be over. I'm not going to wait for anything. This is going to be over. So far, you got 37 perjuries at 15 years each, and then you got 60 years plus $50 million that you owe, and all these perjuries at $15,000 each on lawful money. And we are only on page 2, 3, 4, 5. And page 2, let's see how many you can have, okay? For now, I'm taking a pause. We are going to be continuing on the same page, so we're going to stop the video now.